Any Granas holds that.
You are the petitioner. Why do you want to file an additional affidavit?
On the last occasion, this honorable court had directed an inspection committee. So against the report, we would like to file additional
When did the court direct?
last part of last year. Last part of last year.
Last person. Why didn't you file?
They submitted the report early part of this year.
We'll see when the matter reaches. Don't worry, I will duly take note of. I will duly take note of your request, but when the matter reaches.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item number 26.
20?
26, Your Lordship. Your Lordship, as my senior is on leave under medical treatment, so I beg that let this matter come after 2 weeks.
2016 matter. Poor, shows very poorly. Go ahead, Junior.
Your Lordship, same prayer be reflected on item 8 and 15, Your Lordship.
We'll see when the matter reaches.
For motion, item number 1.
Yes, what is your case?
Petitioner hearing is the grandson of one of the landowners. The agreement is executed, donating the land is executed in 14/02/1972. It's in Annexure A, Lordship. Page 17, Lordship.
What is the date? What is the date of this agreement?
14/02/1972. Lordship. Page 17, Lordship.
Then
Thereafter, the government of Nagaland adopted a policy by notification dated 05/03/2018.
Then
Thereafter, in April 2023, the petitioner had submitted an application to DC Kufri for appointing the petitioner to the post of peon, grade 4, on land ownership basis against the vacant post of peon, grade 4, under the establishment of EAC sitting on the retirement of Sri Litsamong Santam on donation on 31/08/2020.
Then
Then the petitioner appeared before the interview board in the office of the DC Kifuri on 22/09/2023.
Mr. Counsel, your entire case is on the basis of 5/3/2018. 5/3/18 says about two things. 3A says about written agreement, and the second says 3B says about oral agreement. In your written agreement, you have a written agreement. Is it mentioned that you will be given a job?
There is an oral agreement, Lord.
So there is an oral agreement. So have you mentioned anywhere that you had an oral agreement anywhere?
Lord.
Where? Where is it? There's no representation to the effect that you have an oral agreement.
Page 6, para 2, Lord. Of the petition, Lord.
But this agreement, which is there at page 18, does not show that there was any oral agreement. When a document is already written, how do you say that there was an oral agreement? Yes, madam, you are for the government? Yes. When the document is a written document, there is a written agreement that it is freely donated. Isn't it required to say out there that this donation is made in lieu of appointment to be made?
Lordship, yes, yes. As per the agreement, there is no
No mention.
any such thing before impurity.
We do one thing, we issue notice. No stay. This
Lordship,
appointment shall be subject to the outcome of the writ petition. That's all.
The service regulation of the respondent number 5 be subject to the outcome of this petition.
Issue notice making it returnable by 22nd of March 2024. Ms. So-and-so appears on behalf of the respondent numbers 1 to 4
Lordship,
and accepts notice. The petitioner is directed to serve extra copies of the writ petition to her by tomorrow. By tomorrow is by 23 to 2024. As regards the respondent number 5, the petitioner is directed to take steps by way of registered as well as usual.
Dusty service.
In addition to that, the petitioner is also given the liberty to take steps upon the respondent number 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner, that the grandfather of the petitioner, along with others, had donated land for use by the government for Sitimi Circle headquarters and other government departmental requirements. And in that regard, a written agreement was entered into on 14/2/1972. It is a specific case of the petitioner that there was also an oral agreement on the basis of, for the purpose of granting employment in lieu of the land being donated. In that regard, the Learned Council has referred to the notification dated 5/3/2018 and submitted that the Deputy Commissioner, which district? Hifri, have proceeded with and submitted that the district administration had proceeded with the appointment process in respect to the post of multitasking staff bracket MTS grade 4 without considering the notification dated 5/3/2018 and the oral agreement, and as such have challenged the notification dated 12/12/2023, whereby the respondent number 5 was appointed. This court, upon taking into account the materials on record, is not inclined to grant a stay to the appointment order dated 12/12/2023. However, this court observes that the appointment of the respondent number 5 shall be subject to the outcome of the writ petition.
For admission, sorry, for motion, item number 2.
Yes, Your Lordship.
Hmm.
Your Lordship, this is a prayer for grant of minimum scale of pay.
Page, what is the, which is the letter? 8/7/2021. Impugn letter.
Annexure D,
Hmm.
page 17.
Issue notice making it returnable on 23/2024. Ms. So-and-so appears on behalf of the respondent numbers 1 to 6 and accepts notice. Extra copies of the writ petition be served upon her by 23/2/2024. The case of the petitioner herein is that the petitioner is a work charge employee. He's a temporary. You're a casual
Work charge labor.
work charge labor and is entitled to the minimum of the scale of pay as is given to regular grade 4 employees. Full stop. In that regard, the petitioner had earlier submitted a representation and the said representation having not been considered, the petitioner had approached this court by filing a writ petition being WPC number 886/2021, wherein this court disposed of the said writ petition, directing the respondent authorities to consider the representation of the petitioner. Pursuant thereto, on 8/7/2021, the petitioner's representation has been rejected on the ground that the government of Nagaland does not have a policy for granting the minimum scale of pay to the work charge laborers. The entire case of the petitioner is based upon the judgment of the Supreme Court in the case of State of Punjab versus Jagjit Singh, isn't it? Oh, Jagjit Singh reported in so and so, wherein there has been a direction passed by the Supreme Court to the effect that the person that the temporary work charge, temporary / work charge employees who are discharging similar duties as well as has the similar qualification should be granted the minimum scale of pay which is being given to the regular grade for to the regular employees. Taking into account the above, this court directs the respondent authorities to file an affidavit on or before the next date.
For motion, item number 3.
Lordship, at this similar prayer.
Similar case,
Yes, Your Lordship.
same writ petition, no. 8/7. You did not approach earlier.
This also, this matter, this is the third round of litigation.
It will number whole. This number is WPC number 203/2020. Earlier it was 86. 86 now.
Yes, Your Lordship.
Now this is 203/2023 20 and the order dated is 9/12/2020 and the impugn letter is 4/2/2021.
Lordship, Similar, I have the similar period for item number 4, 5, 6, and 7.
Very easy. You just tell him, give him a note as to which are the item number 4, what is the number of the writ petition, the order dated earlier, and the impugn order dated. Okay, so that he will pass the order.
Yes, Your Worship.
For admission, item number 8.
Yes, what is this case?
This is regarding non-payment of pending projects. In the last occasion, the CGC was instructed to obtain some instructions regarding the copying of the funding. This honorable court has directed the CGC.
You are entitled to 18,70,000. What is the stand of the respondents in the affidavit?
Lordship, yes, it is admitted that the petitioner has completed the work. In our affidavit, we have admitted it. But the fact is, Your Lordship, this is not a state project. This is a central project. We were asked to implement the central project. Now, Your Lordship, in the affidavit of this Union of India, they have admitted to the fact that the project belongs to them, and they have dropped the project without funding, without
And the
any
work-
fund.
And the work has been done.
Yes, Your Lordship, the work has been done.
Then
Now, the Union of India is coming with the affidavit stating that yes, the project belongs to them. The project has been dropped. No funding has been provided. But they are now creating a stand that the project was dropped before the work order was issued. That is not so, Your Lordship, in this case.
have they filed the affidavit?
Yes, Your Lordship, they have filed the affidavit.
So their specific stand is the project was dropped.
Yes,
And what is your stand?
Lordship, that is the reason why, because Your
No,
Lordship.
did you file any affidavit pursuant thereto that the project was not dropped?
Your Lordship, the office memorandum through which the project was dropped clearly indicates a date. Now, that date, Your Lordship, is after the work order was issued and the work was completed by the petitioner, hearing the contractors, Your Lordship.
And the union is not represented.
Your Lordship, union was represented by Mr. Gauhati.
Yes, what is your stand?
Any submission. Your Lordship, I don't have any submission.
So we take it that you have no submission and dispose it of directing the union to make the payment within 4 months. The whole. The instant writ petition has been filed by the petitioner, seeking a direction upon the respondent authorities. Now, being aggrieved by the inaction on the part of the respondent authorities in not making payment of an amount of rupees 18,70,250, to which the petitioner claims to be entitled to on the basis of the works duly completed. The record reveals that the petitioner was awarded were issued various work orders for construction of the approach road connecting the government higher secondary school to Chumekedima, package 1, package Roman 2, package Roman 3, and package Roman 4, of an amount of rupees 18,70,250, and package 5, amounting to rupees 18,70,250. The record further reveals that these work orders were issued on 10/3/2015. Thereupon, it is the specific case of the petitioner that the said works were completed when?
Within the given time.
Huh?
Within the given period.
Where is your statement? Where is your completion certificate?
This is admitted, my lord. It's very affidavit of the respondent authorities. Please,
Respond number 5, respond number. Who has filed the affidavit?
And then in my affidavit reply also.
Has- It is the specific case of the petitioner that said works were duly completed. Full stop. In this regard, this court finds it relevant to take note of the affidavit in opposition filed by the respondent numbers 1, 2, and 3, 1, 2, 3, and 4, wherein it has been mentioned when, where is it mentioned that it has been completed?
Not. No, annexure, I page 22.
Annexure?
I page 22 of the
Page
22.
26.
It's not directed next.
No, in your writ petition,
Yes, madam.
writ petition and page 26 is
22.
page 22.
Annexure I. This is a letter. So directed there should be Commissioner Secretary proposing for additional fund for the works which are completed. But this letter they are.
When did you complete? That is a very relevant aspect. Because he says that the work was completed prior to dropping.
Yes, your lordship. In fact, they have mentioned it in the affidavit in reply also.
When did they complete? It has been specifically averred in the writ petition that the works were duly completed. However, the amount to which the petitioner was entitled to was not paid. Under such circumstances, the petitioner issued a legal notice on 25/3/2019 upon the respond number 3 and 4 for payment of the petitioner's entitled amount of rupees 18,70,250. To the said legal notice, the respondent authorities replied that due to non-availability of the fund, the payment could not be made to the petitioner for the completed work till date, as there was no budgetary allocation for the said work. Full stop. To the reply so submitted, given by the respondent number 3 and 4 to the legal notice, a document was enclosed being a communication issued by the additional director and HOD, Directorate of Municipal Affairs, Nagaland, to the Commissioner and Secretary, Department of Municipal Affairs. In the said communication, it was mentioned that the Ministry of Urban Development, Government of India, had sanctioned the project in the inverted comma, integrated development of Chumikedama town roads, bracket close, inverted comma close, under the scheme UIDSSMT, bracket, transition phase of JNRUM, no, JNN, capital N, URM, bracket close, by ministry's letter dated, the ministry's letter bearing number K-14011/19/2013-UD-1 amounting to rupees 1946.43 lakhs. On the basis of that, the department was directed to include the work, inverted comma, premix carpeting work from Government High School Chumekadema to the Town Baptist Church, inverted comma close, and the contractor had completed the work. However, as per the Ministry of Urban Development's Office Memorandum dated 4/8/2015, all projects approved under UIDSSMT where funds could not be released as on 31/3/2014 stood dropped and would not be considered for funding. It was also mentioned that under such circumstances, the payment could not be made released to the petitioner. The petitioner, thereupon being aggrieved, had approached this court by filing the instant writ petition on April 2019. This court, by an order dated 5/7/2019, disposed of the said writ petition, disposed of the instant writ petition, thereby directing the respondents to pay the pending bills of the petitioner as claimed by him after verification of the work claimed to have been executed at the earliest, but not beyond the period of 5 months from the date of the said order. It was also mentioned that the pending bills would carry an interest at the rate of 9% per annum from the date of completion of the work. The record reveals that a review application was filed seeking review of the order dated 5/7/2019 passed in WPC number 86/2019, seeking review of the said order dated 5/7/2019. The said review application was registered and numbered as review petition number 7/2019. By an order dated 10/2/2021, this court had recalled the order dated 5/7/2019, thereby allowing the said review application. Pursuant thereto, the record reveals that the affidavits have been filed by the respondent numbers 1, 2, and 3, as well as the 1, 2, 3, and 4, as well as by the respondent number 5. In the affidavit filed by the respondent numbers 1, 2, 3, and 4, on 16/6/2022, it was mentioned that by an office memorandum dated 4/3/2014, issued by the Government of India Ministry of Urban Development, J_n RUN Directorate, the state government was conveyed on the release of additional central assistance (ACA) to Nagaland for urban infrastructure development under the Urban Infrastructure Development for Small and Medium Town scheme during 2013-14 The said OM dated 4/3/2014, amongst other, provided the modalities for the financial grant oblique assistance under the UIDSSMT scheme, and also the project approved against Sumikedama town at the approved cost of rupees 1946.43 lakhs, in which the eligible central share would be 80%. That is rupees 1751.79 lakhs. And the first installment was projected at rupees 8875.89 lakhs. The Department of Urban Development, Government of Nagaland, was designated as the state-level nodal agency for implementing the UIDSSMT scheme. Consequent to the issuance of the OM dated 4/3/2014, the Government of Nagaland had issued 5 work orders to the petitioner against the construction of the approach road connecting the government higher secondary school to Chumekedama, which have been executed by the petitioner within the time stipulated in the work orders. It was also mentioned that the works undertaken by the petitioner amounted to rupees 18,70,250 is against the project at the Sumekedama town under the UIDSSMT scheme. Further to that, it was stated that the Government of India in the Ministry of Urban Development NURM section had subsequently issued an office memorandum dated 14/8/2015, whereby at serial number 6B of the office memorandum, it was provided that all projects which were approved but funds could not be released as on 31 March 2014 stands dropped and will not be considered for funding. It was also mentioned that the government of Nagaland had issued the 5 work orders dated 10/3/2015 on the basis of the policy decision adopted by the Government of India, which was reflected in the office memorandum dated 4/3/2014. The work undertaken by the petitioner is under the UIDSSMT scheme, which was abruptly dropped by the Government of India, Ministry of Urban Development, after the petitioner had completed the construction allotted to him within the time allotted in the work order, which was issued by the respondent authorities. It was therefore the specific case of the state respondents that it is on account of the dropping of the scheme by the office memorandum dated 14/8/2015 by the Ministry of Urban Development, Government of India, the funds could not be released to the petitioner. The record reveals that the respondent number 5 had filed an affidavit in opposition. In the said affidavit in opposition, it was mentioned that the Jawaharlal Nehru National Urban Renewal Mission was implemented by the Government of India with effect from 3/12/2005 up to 31/3/2012, that is for 7 years beginning from 2006, 5 and 6. The said project, the said JNNURM was extended from 1/4/2012 to 31/3/2014 and was called the transition phase of JNNURM. It was further mentioned that the Ministry of Finance did not release fund for the instant project along with some other projects. The project therefore stood dropped for funding by the central government right from April 2014. The state government was well aware that the fund has not been released for the said project and the transition phase has also ended on 31/3/2014. The said project was therefore not at all eligible for funding by the Government of India. In spite of that, the respondent state government had issued the work orders in 5 packages dated 10/4/2015 with a total cost of 18.70 lakhs only 18.70 lakhs of the said road project almost 1 year after the ending of the transition phase without any consultation with the Ministry of Housing and Urban Affairs. The record reveals that the petitioner have duly filed affidavit in replies to the affidavit in opposition filed with respondent numbers 1, 2, 3, and 4. In the backdrop of the above pleadings, this court have also let this court take into consideration the submissions so made by the learned counsels appearing on behalf of the parties. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the respondent authorities, more particularly the respondent numbers 1 to 4, more particularly the respondent number 3 and respondent number, was it in pursuance to any tender? Was it in pursuance to any tender?
It was a table tender. It was only a table tender because the amount is small.
Had submitted that that the respondent number 4 had issued the work order on 10/4/2015, and on the basis thereof, the petitioner had duly completed the work. Under such circumstances, the petitioner would be entitled to the said amount of rupees 18,70,000, which is being duly admitted by the state respondents. It is also mentioned it is also submitted by the learned counsel for the petitioner that neither the work order did not reflect that the said amount is to be received, that the said work was to be completed in connection with a central government funding. It is therefore the specific case of the petitioner that the petitioner is entitled to the said amount of rupees 18,70,000. Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 1 to 4, submitted on the basis of the pleadings, stating inter alia that the work orders were issued on the basis of the assurance given by the central government in its office memorandum dated 4/3/2014. And under such circumstances, the withdrawal of the said office memorandum, under such circumstances, the dropping of the said project by an office memorandum dated 10/8/2015,
14/8/2015.
14/8/2015, cannot bind the state respondents to make payment. I cannot bind the state respondents. And 14/8, but the dropping of the said project by an office memorandum dated 14/8/2015 by the central government, by the respondent number 5. That too, after the completion of the project in question. cannot dissolve the liability to which the respondent number 5 was liable to pay. Yes, you. What do you have to say? You have nothing to say.
Your Lordship, I don't have any direction from my senior.
Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 5 submitted that the state of Nagaland very well knew that the JNNURM was not extended beyond 31/3/2014. And under such circumstances, the issuance of the work order by the respondents, that too without consultation with the ministry, cannot make the Union of India liable for that. This court have duly perused the pleadings as above noted, and have also given an anxious consideration to the respective submissions made by the learned counsels for the parties. That the fact that the petitioner herein was issued work orders on 10/4/2015 is not in dispute. The fact that the petitioner duly completed the work in question to the satisfaction of the respondent number 3 and 4 is also not in dispute. The question which is in dispute is as to who would be liable to pay the petitioner. First, the work order which have been enclosed to the petition do not in any manner show that the said works orders were issued in pursuance to any implementation of a central government assisted scheme. The said work orders categorically show that the said amount that the petitioner was asked to complete the said work, and accordingly the petitioner have duly completed. Under such circumstances, non-payment of the amount by the respondent numbers 1, 2, 3, and 4 amounts to an infraction to the rights of the petitioners under 300A of the Constitution, apart from being arbitrary and unreasonable, thereby rendering the inaction on the part of the respondent authorities of not paying of the amount as violative of Article 14 of the Constitution. Under such circumstances, this court directs the respondent numbers 1 to 4 to disburse the amount of rupees 18,70,000 to the petitioner within a period of 4 months from the date a certified copy of the instant order is served upon the respondent number 3. This court have not decided as to whether the state of Nagaland would be entitled to the assistance from the respondent number 5, that is the Ministry of Urban Affairs, Government of India. And under such circumstances, it shall be open to the state of Nagaland to pursue such remedies against the respondent number 5, claiming such amount which the respondent numbers 1 to 4 had been directed to pay. The above, the petition stands disposed.
For admission, item numbers 9 to 12.
What is this?
Here the main counsel is on leave, Your Lordship. So I pray short date may be allowed.
Regularize the services.
Yes, Your Lordship.
Under what provision?
Syndrome pension scheme, Your Lordship.
Under?
CCS.
Regularize the services. of the petitioner to grant all pensionary benefits. You have worked for 35 years?
Yes, Your Lordship.
When were you appointed? Was joined in the service on 18/8/2084. However, initial appointment order could not be traced out in the office and the personal OP was misplaced, hence we are recorded.
Your Lordship, the main counsel is on leave.
Don't worry, I'll help you out if you have a case. Your case comes under the 17/3/2015 notification,
Yes, sir.
having completed 35 years.
Yes, sir.
Any of the government, because
Huh?
it doesn't have under any of the policy for regularization under the government of Maryland.
Why?
Because he is a fixed pay level. He is a fixed pay.
Fixed pay is not under 73.
No, not under 2015. He will become under 2004 if he is the senior most. But at the time of his release, he stands at serial number 26. So he is paying for the service regularization under the CCS pension rules.
CCS pension.
Yes. So your lordship,
How will the CCS pension will come? First you have to regularize it.
yes, yes,
Then only the question of CCS pension,
yes, yes.
because the pension is only paid to those persons
Yes,
who are in the cadre.
yes, yes, your lordship.
So unless he is not in the cadre, the question does not arise.
And I said, your lordship, your judgment is ordered because 8/6/2023, which your lordship, Justice Sumanchan had passed the order on 8/2023.
It's covered by that.
Yes. When covered,
Is it? You've gone to the judgment.
Oh, Your Lordship. There is a recent judgment which holds my case.
Which one?
Read 35 of 2022.
Yes, what did it say? What is this case about?
Lordship, that was erroneously passed. So for that matter, the department is going to approach the going to file the SLP, your lordship.
Your Lordship, particularly page number 8, point number 2, 3, 4.
You were not enjoying the scale of pay.
No, Your Lordship.
So therefore you don't come under 17/3/2015.
Yes, sir.
It is only those persons who were enjoying a scale of pay
Yes, sir.
and thereupon have completed 30 years would be entitled as per 17/3.
Yes.
Now, under what basis this court has done this? Under what basis?
Your Lordship, if I may. All the
Let
petitioners.
let
have
me go
served
through
for
the judgment of the
35 days.
division bench. Wait. Yes. This is let's see the CCS rules. You see, the judgment passed by the division bench in Writ Appeal 35 of 2022 may not strictly apply to you. Because in that case, there was a attempt made asking that he should be given the regular scale of pay. The representation was filed there, and that was not considered. And therefore, the court took into account Jagjit Singh and thereupon also held that the division bench judgment, earlier division bench judgment, is per incuriam in view of the fact that the earlier two division bench judgments were not taken into account. But whatever may be, the court went into the question that there was an application being filed requesting for a regular scale of pay, which was not given, and as such, brought it within the ambit of 17.3. So that is one aspect. But you never applied for the regular scale of pay during your service. If you are not, so the question of being regularized under that provision does not arise. But the question will be as to whether, in view of clause 2, rule 2 of the CCS rules, because CCS rules have been admitted here, na? Where is that temporary servant with less than 10 years service who retires on superannuation discharge from is eligible for gratuity as permanent demand?
It talks about a government servant.
Hmm?
So it talks about a government servant holding a substantive post.
No.
Yes.
There is another one. He had quoted one thing out there in paragraph number
Yes.
11 of his
Lordship, in
petition.
your judgment, that is in my affidavit in opposition, that your lordship and justice Sumanshan have clearly made sure that is in my affidavit in opposition. I have
Ah.
annexed the judgment.
Affidavit in opposition, yes, OM.
Yes. Page 30.
Yes, grant of government orders. Here, if we read it at page 14, it is incomplete document you have enclosed. Why not the entire thing?
Because the entire one he has reproduced in his Greek petition.
Then why did you feel the need of at all enclosing it? Now, these are Government of India orders. So are these Government of India orders, you are bound by that?
We follow this CCS pension rules.
So along with all orders passed by the Government of India?
Only some, your lordship, only when we brought out the
Huh?
notification.
The above recommendation of the pay committee has been considered and it has been decided that temporary government servant who retires on superannuation or discharged from service or declared invalid for further service or absorbed in an autonomous body before years shall be entitled to gratuity. 1996. Employees of the Union of territories are to be governed by the CCS. No distinction with permanent and in the application of it. Confirmation will be made only once in the service of year. Confirmation is dealing to years since all persons who complete probation. Did you apply during your period for regularization?
Yes, Your Lordship.
When? Because here it is, you have stated.
Yes, only after he was made to retire in 2020.
I'm sorry, Your Lordship, after retirement.
Yes.
After retirement,
Yes.
not during that
No,
period.
Yes,
yeah?
yes.
so-
Knowing fully well may not come because you didn't have
Yes.
the document as to whether you completed because you don't have any except the I card.
Yes, sir.
So you don't have the order copy.
So even in his petition.
What about the judgment in the case of recently given in the case by Justice M.R. Shah?
That Nishivi.
No. The other one. Nisivi is a different case. Nisivi is a case where a person during his lifetime had never applied for regularization. And thereupon, after his death, his wife wanted to do so, that too after a period of 12 years. But otherwise also, that person concerned would not have been entitled to regularization. So that is another aspect on Nisivi. But he is not on Nisivi, he is on the basis of CCS. Now CCS, if it permits, and there is another judgment of the Supreme Court of also Justice M.R. Shah, wait, wherein it says that a person who have been working for, you can't, having allowed him to work for 30 years, you can't just throw him out. I think it is mentioned here. Yes, this judgment. Dasilbi Bhai Thanji Bhai Patel. That's one I suppose. Read this judgment, sir. This is so. This is by Justice M.R. Shah and B.V. Nagaratna. And what the here, this paragraph, it starts and finishes? No. No, there is another judgment. We'll do one thing. We'll take it up tomorrow. I'll have that particular judgment. Wherein the Supreme Court says there is another judgment. I had it in wherein the Supreme Court says that if this person concerned has been working for, this is only a one paragraph judgment, this one, the Talsi Bhai. But the other case is, Supreme Court says that if you are taking his services all this time and he was entitled to at that point of time, having not considered it, then obviously he will be entitled to pension. We'll take it up tomorrow. Like I delivered judgments on this point out there. because in Assam, you have the Assam pension rules. Assam pension rules, there is an office memorandum which is similar to this rule too, which says that a person who have been working temporarily for a period of 20 years, I suppose, would be entitled to the pensionary benefits on temporary basis. There, now, you just find out as to whether that government order would be applicable, because it is not in the rule. This is not in the rule. If you see in your affidavit which you have enclosed, it is not in the rule which have been enclosed. You see, these are Government of India orders. Whether you are bound by these orders. And get me the full one. This one is, what is this?
The CCS pension rules
Huh?
that are, yes, from there on.
I couldn't find it where it is. CCS pension rules 1972.
The applicability.
CCS pension there, rule 2. This is number 1. Number 1 says, so and so employees of the Delhi administration as well as union territories in the matter of so and so area, the pay scales and other conditions of the union has been fixed on the basis of recommendation by the Third Pay Commission. This is one. What is the date of this? Why haven't you brought the entire thing? 1987. That part is not here.
I'll produce tomorrow motion.
You produced the entire thing, huh?
Motion.
Hearing remains inconclusive. Mrs. A, the learned AAG shall produce the entire portion of annexure. What is that? Of the document enclosed as annexure.
Annexure,
Answer 5.
annexure 4.
Annexure 4 to her affidavit in opposition tomorrow. Yes, Mr. Counsel, you need to find out the judgment. That is a judgment delivered by Justice M.R. sir. It's a long judgment. I have just find it out.
Yes, sir.
Tomorrow.
For admission, item number 13 and 14.
Yes.
Yes, my lord. About the item 13 and 14, they are analogous matters. These groups of petitioners, they were dismissed from service. So we challenged the dismissal. Then we succeeded, they were reinstated in service. So for the period which they did not work, during that intervening period, the increment has not been given to them. That is the challenge here, Your Lordship. And
In both the petitions.
in both the petitions. So when the petition was
What's
first
the
filed,
order dated 27/8/2018? What is that?
Your Lordship, when the petition was first filed, we did not have a copy of the order by which the increments were returned to us. After they filed the interim opposition, we got that order, then.
So
we amended
therefore, the
petition.
second writ petition.
Yes, we amended the petition. And to the amended petition, they have not filed their.
Uh-huh.
To the amended petition,
The second writ petition.
yes,
But anyways, the question is,
my lord.
you were dismissed
Yes, ma'am.
from service.
Yes, ma'am.
On whatever may be.
My lord.
Thereupon, you were reinstated.
Yes, ma'am.
That order was set aside by whom? The order of dismissal?
By this court, Your Lordship.
Okay. Now let us see that order.
Your Lordship, the order was to reinstate us in service.
No. Let us see.
And the impugn order was set aside.
Let us see that order. Because if it is a reinstatement, absolutely.
Yes, my
And
lord.
by setting aside in
Yes, my
thing,
lord.
on the ground that there was a mistake committed by whatever the authority,
My lord.
then obviously, and they thereupon have reinstated
Yes, my
you,
lord.
then you are entitled to whatever service benefits
Yes,
you
ma'am.
are. So that's it.
Yes, sir.
Let us see that order
Page 29.
of
Page 29.
Which-
Of the writ petition.
which one you have to.
The first one, the amended writ petition, WPC number 50 of 2021.
Yeah.
Page 29.
29. Yes. Let us see
Page
this.
29, the main portion.
Having regard to the involvement, I will consider the revision needs not be kept pending. Instead, are disposed of directing inquiry to finalize the matter expeditiously, preferably on demand, depending upon the other authorities and pass it. No adverse order shall be passed against the without. As regards the payment of the court. So nothing was done here.
No,
This court did not do. Thereupon what happened?
Next order is at page 39.
So you challenge some dismissal order.
Yes, madam.
Pursuant to Justice B.K. Sharma's order, there was a dismissal
Yes,
order. You challenged it.
Yes, madam.
In WPC number 157.
Yes, madam.
Then
And finally,
on consideration and as discussed, is of the opinion that the petitioners have been made out a case calling for in according that the impugned order dated insofar the petitioners are concerned as set aside and quashed are directed to forfeit, reinstate the petitioner back in service. However, the petitioner shall not be entitled
49,
to
yes.
any back wages. Liberty is also granted to the petitioner, respondent number 3, to conduct a fresh inquiry against the petitioner if so advised. This was done on the basis of some technical infractions,
Yes, madam.
because there was some
Yes, ma'am.
violation of
Yes, ma'am.
something, I suppose. Okay. Then, but there is no back wages.
No back wages.
Now, how do you calculate the increment without back wages?
Your lordship, notional on the basis of, on notional basis, your lordship. On notional basis.
See, as far as I know, a person, if he is in service,
My lord.
he is entitled to his pay.
Yes,
Withholding a amount
yes, my lord.
or saying that he is not entitled to a pay
My lord.
also amounts to a penalty.
Yes, my lord. It amounts to a penalty, yes.
Have you challenged that?
Yes, my lord, I've challenged that.
This
I've challenged
appeal-
that in this petition.
No,
That's
no,
why-
no, no. How can you challenge here?
Which one, my lord?
The judgment passed by Justice Jameel
Yes, my lord.
says that you are to be reinstated,
My lord.
but the petitioner would not be entitled to back wages.
Yes, my lord.
Thereby, isn't that amounts to a penalty?
My lord, my humble submission is that it would not amount to a penalty.
Why? How can you stop a person from not getting his salary?
Because he has not worked for that period. For that intervening period.
On the ground of no pay, no work.
Yes, my lord. And he has not worked, I accept that. We have not worked for that period, I accept that, my lord. But at least the increment should be given to me. That part cannot be treated as a break in service, my lord, we appreciate that.
Because not giving you the increment amounts to a major penalty
Yes,
without
ma'am.
following the due process.
Without due process, yes. Ma'am.
Because I think you are under the CCS?
We have our own rules as far as disciplinary proceedings are concerned.
Yes. Mr. Jimami, what are the rules?
Without due process, not possible to impose penalty.
Because that amounts to a penalty.
Yes,
And you cannot impose a penalty without
Without
a
due process.
disciplinary inquiry.
yes, ma'am.
So withholding of the increment amounts to a penalty.
Yes, madam.
That's your case.
Yes, ma'am.
Lordship, since the petitioner that had filed the amended petition, and
Amended petition for what?
Lordship, earlier they have filed the
They issued an order, Your Lordship, after the filing of the writ petition initially. Earlier it was just withholding of increments. After they filed their affidavit of opposition in the unamended writ petition, they enclosed an order by which the increments were withheld.
Show me.
Annexure 15 at page. Page 78.
Page
78.
Yeah.
The type copied at page 79.
In continuation of the end under so and so, as per the honorable court's order passed in so and so and so and so and so and so, they will be paid their arrears from 1 fact. However, the incumbent will not be entitled to any back wages with effect from.
Last
Therefore,
paragraph before the
period
table.
of Iman to year will not be
Therefore, the period
counted
with
for
effect from
qualifying
28
service
15
nor for
3618 will not be counted for qualifying service nor for increment.
How can you do that? Now, wouldn't that be stoppage of increment? How can you stop an increment? Show me.
Since this order was passed by the
You are not representing the director of health service.
I'm paying lordship, but however, without any instruction.
When this was filed on 14th of December. And you pass an order, you don't know why you have passed that order. Okay, how much time?
3 weeks time. 3 weeks time.
Mr. B. Jimomi appearing on behalf of the respondent seeks for an accommodation of 3 weeks for filing the affidavit in opposition to the amended writ petition. 3 weeks, this court fixes the matter again on 18th of March 2024. The affidavit in opposition
After the 18, my lord, 18 till the 20th I'll be out of station.
fixes a matter on 26th of March.
Yes, my lord.
Okay, 26th of March 2024. The affidavit in opposition be filed by 15th of March 2024. The petitioner, if so advised, would be at liberty to file the reply on or before the next date.
For admission, item number 15.
Your Lordship. Your Lordship, I'm standing on behalf of my senior Gauhati. Your Lordship, as my senior is on leave under medical ground, so I better let this matter come after 2 weeks. Your Lordship.
So you have been discharged from service? Having heard the learned counsels for the parties and taking into account that the pleadings are duly complete, this court admits the instant writ petition and issues rule. Taking into account that the pleadings are duly complete, this court directs the writ petition to be listed for hearing on 21st of March 2024.
For admission, item number 16.
Yes, no government advocate?
It's coming, my lord.
What is their stand in the affidavit? Are you presently being considered?
My lord.
So you will be considered
My
as
lord,
per the affidavit in reply. Affidavit in opposition, you are at serial number 191.
my grievance is, my lord,
in the affidavit, which is a government file, my serial number is at 212.
Yes.
But at the latest roster maintained by the department, my serial number is now at 71. So from 1 to 70, no appointment has been made. And on the affidavit filed by the government, on page 2, stated that appointment was made till serial number 191, and my number stand as 212.
212.
Yeah, so only 22 number in front of me, applicant in front of me. But now I'm standing at serial number 71, whereas there are 70 applicant in front of me. And my lord, my grievance is also that as per my RTI, as per the RTI reply, no appointment has been made to the post of grade 3 from 2020 till May 2023. And office memorandum clearly state group C and D post, and grade 3 falls under group C post, my lord. And the petitioner has MA degree and a diploma in computer application, my lord.
So you don't want to join in group 4?
I'm eligible for group C, my lord. But the department have not made any appointment since 2020 till date. And my lord, on my affidavit, I have annexed on page 7 the reply of the department.
But Mr. Counsel, are you aware of the fact that a person has compassionate appointment is not a source of recruitment?
Yes, my lord, but
It is being given on the basis of tiding out from the difficulties which is being faced. You can't have a choice that I like this or that. If it is a group 4 or grade 4, you have to accept it. It is your job. Thereafter, it becomes a regular appointment, then you give your exams, you become in group 3 or grade 3. You will consider. But as of now, you don't have a right that, okay, I only want in group 3, because your representation also says that you are eligible for group 3, grade 3 and grade 4, which have not been considered. That is your specific case. In your representation, you kindly see where I have seen it somewhere.
page 15, my lord, my application.
In your affidavit in reply or somewhere. Yes, madam.
Since the department is one since your serial number falls in serial number 71 motion,
71 now.
71 motion.
Earlier you said that it was in the affidavit, it was mentioned as he is in 212.
Yes, Lordship, but I have received the recent one motion as on December 2023.
Now he is 71.
Yes, Lordship,
Of, and how many above him are there?
70 of them, Lordship.
So earlier it was less.
Earlier it was 212, Lordship.
Huh?
Earlier she was in serial number 212, Lordship. But now as
Now earlier he was in 212
Lordship.
on the basis of 191 having already been appointed, which means him at 12 plus another 9 and 21 persons above him.
Lordship.
Now you are putting him at 71, which makes him another 70 above him.
Lordship.
Why?
It has to go according to chronological order, Lordship.
Huh?
The department, they maintain a roster of Lordship.
Understood, but your roster in your affidavit is very clear that earlier it was 191 persons have already been given. Up till 191 it has been already done, and he is in 2012. He is number 212. So thereby it is only 21 persons above him. Now how did your change your what do you call, stand changed to 70, making him 71 now. Now 70 is above him.
Lordship,
Where's your affidavit? What is your stand? Means how do this court know this?
That's why I have to receive also with me, Lordship, I need.
Show me. When did the father of the petitioner die? 21. Madam, if you look into your scheme, which you are having, the scheme is enclosed out here at page annexure A to the petition. That is 17/9/2015. Thereupon, there is another addendum brought in on 9/4/2019, which makes whereby clause 11 was incorporated, which says that it will be taken on the basis of the actual date of death of the person, isn't it? Now, if that be so, this court very well understands the other aspects of the matter. The father of the petitioner expired on 16/1/2020. If that be so, why the petitioner should not be taken into account at around 62? You have a copy of this? No, you have it. Kindly come to page serial number 62. The person's father expired on 21/2020, whereas the petitioner's father expired on 16/1/2020. Maybe number 63 should be above 62. If we go as per the 9/4/2019. What is your basis of putting him at 17 if we go by that? Just for example, number 23, if you see. This person's father, or whoever it is, expired on 2014. Whereas number 22 is 2016. What is the basis? Is that in conformity with your clause 11?
My lord, the roster is not fair, my lord. So if,
Not fair.
if I were to follow this, so the latest roster, I may have to wait for another 5 years. It may never come, my lord. And since the family is facing hardship, I pray for the Honorable Court so to kindly consider at the earliest. And the department is bound to make some
But can
adjustment.
this court pass a direction for you to jump in view of clause 11?
My lord, my humble prayer is that department has not
Mr.
followed the.
Counsel, you have not challenged the office memorandum. Neither the clause 11, which was brought by the addendum dated 9/4/2019. You have not challenged that. So we are to go as per that. So as per that, they have to fix it. Isn't it?
My lord, please allow me to give my submission, my lord.
Please do. You have
My
liberty.
brief submission is that the department is bound to adjust as part of Group C and D, but department have not adjust the Group C post, only Group D post. So I may never know, the Honorable Court may never know if the department have fairly arranged the list and appointment made. If in the interest of justice, if the court inclined to pass direction to the state to furnish the appointment and the future vacancy in the Group C post. Because the latest roster itself, the list of date is not going to the
So
date of
you
date.
mean to say there has to be a separate list for group 4 and group 3?
Yes, my lord.
And if it is group 4 and group 3, it is separately taken and then it has to be taken into account as per the addendum?
Yes, my lord.
First come, first, no,
Yes, my lord.
first person who dies would be given the benefit and the
Yes, my lord.
second person, the
I'm not asking for special treatment, my lord, but we cannot rely on the latest roster maintained by the department also.
Sure. We dispose it of. Where is the addendum of 19 and 19.4?
Yes, on page 22, my lord.
Huh?
On page 22, my lord.
Page
22.
22. Okay. Sure. The instant writ petition heard Mr. So-and-so, the learned counsel for the petitioner, and Mr. So-and-so, Ms. So-and-so appearing on behalf of the respondent numbers 1 to 4. The instant writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in not considering the case of the petitioner for appointment in any grade 3 post in the department against the post reserved for compassionate appointment. And further seeking a direction upon the respondent authorities to adhere to the conditions stipulated in the office memorandum dated 17/9/2015 and the addendum dated 9/4/2019. From the materials on record, it reveals that the father of the petitioner was working as the
Drawing teacher.
was working as a drawing teacher of the government middle school, Kohima, under the establishment of the Deputy Inspector of Schools, Kohima, who unfortunately, he expired on 16/1/2020 while in service. Thereupon, the petitioner, who is what is your qualification?
MA and diploma in computer application, my lord.
No, BA, not
MA.
MA. Not BA. When did you complete your MA? Kindly see Annex D, page 15. BA Sociology Diploma in Computer. Isn't it?
On page 20, my lord.
Huh?
My lord, I've completed MA, but I have not annexed my MA qualification.
We go as per what you have stated. Thereupon the petitioner, who is a graduate with sociology honors and a diploma in computer, submitted an application to the principal director, School Education Department, to be appointed on compassionate basis, on compassionate grounds, to the vacant post of the drawing teacher or the graduate teacher. The said application was filed when? No date. No date. Go by this one. The said application was filed on
17/9/21.
17/9/2021. Before the petitioner is agreed by the inaction on the part of the respondent authorities in not considering his application for being appointed on compassionate grounds, and also by the actions of the respondent authorities in not adhering to the office memorandum dated 17/9/2015 and the addendum dated 9/4/2019. Under such circumstances, the instant writ petition was filed on 1/2/2023. The record reveals that an affidavit in opposition was filed by the state respondents on 3/5/2023, stating inter alia that the petitioner's case was duly considered and he was in the waiting list. As per the said affidavit in opposition, it was categorically mentioned that as per the waiting list, the petitioner's name figures as serial number 212 until the date of filing of the affidavit in opposition. The appointment on compassionate scheme was made up to serial number 191. To the said affidavit in opposition, the petitioner had submitted an affidavit in reply stating inter alia that on the basis of information received under the Right to Information Act 2005, around 113 persons were appointed against the vacant post in grade 4 in the department from 2020 till the time of furnishing of the information. However, there has been no appointment in grade 3 from 2020 till the time of furnishing of the information. It has been specifically averred that the respondents are not adhering to the office memorandum dated, it is 17/9, na?
Yes, my lord.
Why have you made it in 19/9? 17/9/2015. Today, when the matter has been taken up, Ms. So-and-so, appearing on behalf of the respondent state, have placed before this court an instruction dated 20/2/2024, wherein it has been mentioned that the petitioners that as per the roster list for compassionate appointment as on December 2023, the petitioner name appears at serial number 71. This court have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the said submissions. From the materials on record, it reveals that the government of Nagaland, in its Personnel and Administrative Reforms Department, had issued office memorandum dated 17/9/2015 for this office memorandum is in relation to appointment on compassionate ground of family members of government, state government employees who die in harness. There are various clauses in the said office memorandum, but it is relevant to take note of. That in terms of clause 3, appointment on compassionate grounds shall be made only on regular basis to direct recruitment post and only if regular vacancies meant for that purpose are available in the department where the deceased government employee was serving. In clause 4, it has been mentioned that a compassionate appointment may be made to the post falling under the combined direct recruitment quota of Group C or Group D. The ceiling for compassionate appointment of 5% of the direct recruitment vacancies in Group C and Group D post have been done away with, provided such appointment do not exceed 50% of the vacancy during a year. It has also mandated that the appointment against post for direct recruitment in Group C should be in the entry gate only. And further, appointment against any post for direct recruitment in Group C should be limited to those posts which are outside the purview of NPSC for recruitment. Clause 6 categorically mentions that the scheme would be available to family members to the family of the deceased employee, provided no surviving member of the family holds any regular post in the state government. And the benefit of such appointment shall be available to only one family member. Clause 8 refers to the upper age limit of applicants under this scheme, which may be relaxed in exceptional cases up to a maximum of 5 years in addition to the existing relaxation, if any. The lower age limit shall, however, in no case be relaxed below 18 years of age. Pursuant to the said office memorandum dated 17/9/2015, an addendum dated 9/4/2019 was issued, whereby clauses 11 and 12 were inserted to the office memorandum dated 17/9/2015. Clause 11 is very pertinent for the purpose of deciding the instant dispute, inasmuch as the said clause stipulates that the compassionate appointment made to clause Group C and D post under the scheme shall be strictly in order of the date of death, and first preference shall always be given against those who had died earlier and who fulfills all other eligibility criteria. In the backdrop of the above, if this court, in the backdrop of the above, this court finds it very pertinent to take note of the document which have been placed before this court by the Learned State Council dated 20/2/2024, wherein the roster list for compassionate appointment as on December 2023 have been enclosed. The said document, being pertinent, is kept on record and marked with the letter X. The Learned State Council has submitted that the petitioner's case is under consideration and the petitioner's position stands at serial number 71. This court duly takes note of that. Takes note of that the father of the petitioner expired on 16/1/2020.
Yes, ma'am.
And the petitioner submitted his application on 17/9/2021. However, it is seen that the said roster list, so maintained, is not in accordance with clause 11 of the office memorandum dated 17/9/2015, as was inserted by the addendum dated 9/4/2019. This aspect of the matter would be apparent from the fact that there are various other persons. Apparent from the fact that at serial number 53, the person at serial number apparent from the fact that in respect of the person at serial number 53, her father expired on 31/7/2020, whereas the father of the petitioner expired on 16/1/2020. The said, in the opinion of this court, is a serious infraction to clause 11 of the office memorandum dated 17/9/2015, as was inserted by the addendum dated 9/4/2019. Taking into account the above, this court disposes of the instant writ petition, directing the respondent authorities to consider the case of the petitioner strictly in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. The roster list which have been placed before this court, the same needs to be corrected, as apparently the same appears to be in conflict with clause number 11 of the office memorandum dated 17/9/2015. Full stop. Apart from the above, this court also finds it relevant to observe that the office memorandum dated 17/9/2015 categorically mandates granting appointments on compassionate basis to Group C and Group D posts. Under such circumstances, post. Further to that, it is also seen from clause 4 of the said office memorandum that that for the purpose of further to that, it is also seen, it is also very relevant to take note of that it is a well-settled principle of law that a person claiming compassionate appointment cannot claim an appointment higher to the post held by the person who expired, a person who died in harness. It is also very pertinent to take note of that for the purpose of appointment to Group C or Group D, there is a requirement of the minimum qualifications. Under such circumstances, it is of the this court is of the opinion that the respondent authorities have to take the same into consideration while preparing the roster list. Accordingly, the instant court, this court therefore disposes of the instant writ petition with a direction to the respondents to consider the case of the petitioner in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019, and also making necessary correction to the roster list which was being produced before this court on the basis of the said office memorandum dated 17/9/2015 and the addendum dated 9/4/2019. Further to that, the respondents shall also take into consideration the requirements of Group C and Group D posts being different. Due consideration be made for having separate roster lists.
For admission, item number 17.
Yes, Sir Lordship. Lordship, I'm appearing on behalf of Mr. Tushi Olongkumar, the learned counsel for the petitioner. Lordship, I was just informed this morning that there was a medical emergency in the family. So that is.
Don't worry. I would not pass any order prejudicial to you. Let me just see what can I do. Landowner,
Your Lordship, in the earlier occasion, petitioner had sought time to file reply to the affidavit filed by the state.
why this landowner, nowadays everything has to be done in terms with that. Who is appearing for respond number 4? You have filed your affidavit. What is your stand? There is no oral or written agreement.
Your Lordship, there was earlier a certificate wherein the landowners, they have declared that they will not claim for any service opportunities.
Willingness certificate.
It's at annexure A. The type copy is at page 9.
A land offered by us as per the sketch map prior with by so and so, we have solemnly taken the contents of the letter. So they say that there was a oral agreement.
Your Lordship, this is not exactly an oral agreement. This is a willingness certificate which the landowners had signed before the magistrate. And at serial number 13 is the petitioner's grandfather.
Also, in addition to now, what is this at page 11?
Your Lordship, there's a private respondent here also. The private respondent's appointment.
What is this page 11? Of your affidavit?
Assessment of land, the description of the land.
What is that? The land offered by each individual owner is situated below the so and so and within reach of so and so. There is no water source inside the compound acquired by us, though there are 2 so and so. The soil is satisfactory in some portion of the land is here as fixed by the revenue of the none. It has been agreed and brought that the land portion that is in addition to the payment of the year, the landowner will be given small contract work such as after leveling approach road. If department think the landowner suitable for works. Then so your basic case is that there was no agreement.
Yes, Your Lordship.
So you want to file reply.
Yes, Lordship.
And what is the interim order passed?
Lordship, I'm not aware with the facts of this.
So there is a stay.
The approval order of the private respondent.
Madam, we'll have it next week.
Yes, Lordship.
You have to file it because there is a stay.
That will be filed today.
The record reveals that an affidavit in opposition was filed on 19/9/2023, wherein it has been categorically mentioned that there was no written or oral agreement for granting employment. And under such circumstances, the petitioner herein is not entitled to be considered for appointment on land ownership basis. The petitioner, the record further reveals that the petitioner has sought for time on various occasions for filing the reply. But no such affidavit no reply has been filed. This court have also taken note of that an interim order has been passed. Thereby, the appointment of the private respondent has been stayed, which is causing inconvenience to the state respondents. Considering the above, this court grants a final opportunity to the petitioner to file the reply on or before 27/2/2024. Full stop. The matter be again taken up for consideration on 29/2/2024.
For admission, item number 18.
Interim order passed earlier shall continue till the next date. Yes. What is this?
This pertains to the suspension of the service of the GBs by the Deputy Commissioner, Kohima Lordship.
What are you challenging? Dilate
Yes.
the statute to allow the petitioner to function as GB of so and so in view of the appointment order.
Now, Lordship, we have been duly appointed by the government, Lordship. On approval of the government, our appointment order has been issued. Lordship, as far as the service condition of the GBs is concerned, the government has issued a notification dated 9 April 2010, Annexure A, Lordship.
Yes.
So this is the notification governing our service conditions, Lordship. Nowhere in the notification provides for suspension except disqualification, Lordship.
And what is the period?
Lordship, there's no period mentioned out here, Lordship. Now, Lordship, coming to the impugn order, Lordship, may kindly come to Annexure E, page 31. By this impugn order, Lordship, there was some allegation against the village council, Lordship, village council members by different NGOs of the village. And based on the complaint, Lordship, our service has been suspended by this order. This is order dated 31st May 2022. We belong to it, Lordship. Whereas it has come to the notice of the office of the undersigned through multiple complaints and representation that the present village council of the Tolozuma village is not able to function according to the norms of the Nagaland Village Council Act 1978 and BDB Model Rule 1980. And the council and GBs have lost confidence of the public. Lordship, this is important. The council and the GB. Confidence of the public in general and of Tolozuma village. The same has been brought forth through recurrent complaints, public demonstration and protest. The Tolozuma Village Council, despite being a government mandate body, as alleged by various groups and public of the Tolozuma, have failed to exercise and function their authority within their village jurisdiction in effective execution of government directions and programs.
Where's the Nagaland Village Council Act?
Lordship.
Nagaland Village Council Act?
Yes.
Which?
Now, in exercise of power under section 22, where it provides for the administration to take over the village council if there's any dispute, Lordship, as far as the village council is concerned. Section 22. Lordship. This provision of the Act empowers the government to take over the village council if there's an internal dispute within the village council.
And the Gauhati is under what provision?
We don't fall under the Village Council Act, Lordship. Village Council Act is only for the village council members.
But this is, they are not suspending the Gauhatis.
No, Lordship, may kindly come to
For
the...
free and fair investigation of the allegations against the council, that so-and-so council and its subsidiary bodies such as the village development body stands temporarily suspended till further orders in accordance with 22. Further in the interest so-and-so, so village council is being taken over.
Taken over.
Who are you?
We are the GBs, Gamburas.
Now where is the GP being suspended?
Lordship, Lordship, I was reading the first paragraph, that's why. First paragraph says, in that order, the village council and the GBs
Understood, the village
Yes.
council have lost confidence,
Yes,
but the suspension is only for the village council.
we have been directed not to function, Lordship. There's a subsequent orders, Lordship.
Where is it?
Lordship, may kindly come to page 37. By this order, the affairs of the village has been taken over by the administration.
So where is it? How is the GBs affected?
We have been directed not to function, Lordship,
Where?
by this European order, Lordship.
Which order? It doesn't
The
say
31st.
anything.
They did not specifically
This
say.
order does not say anything about Gambulas. This order doesn't say anything about the Gambulas.
The subsidiary,
Are you saying that you fall under the subsidiaries?
yes, Lordship. They
No.
have included us.
And
No.
subsidiary bodies such as village development boards, it has been specified. Are you a village development board?
No, Lordship,
Then-
including the GBs.
Where? Such as
No, Lordship.
subsidiary bodies. Are you a subsidiary body of
Yes.
the village council?
Lordship, may kindly come to page 41, annexure L.
Let us see whether the village council has subsidiary bodies. Who will be, subsidiary means who have
The
anything
VDBs,
to-
Lordship.
As per the act, does it say who are the, there is a village council, who are the subsidiary bodies? Nothing,
Nothing has been mentioned.
then you are
Now,
not
Lordship,
suspended.
may kindly come to page 41, annexure L.
Before going further, let me,
I've been summoned,
no, understood.
Lordship.
After going everything and then if the state government says that we are to file an affidavit, it will do portray very poorly.
Lordship.
Let me ask the state government. Yes,
Lordship has writing copy of Lordship. Lordship. Yeah,
so there is no question of filing any pleadings by you.
Lordship, I have filed my.
You have all the instructions with you. Now tell me whether the GPs have been suspended.
No, Lordship. GB has not been suspended. No. In fact, the one, the
We'll
petitioner
take it,
number
here
one.
the GPs, this order they shall not include the GPs, matter
Lordship,
ends.
Lordship.
Lordship. But however, Lordship, subsequently, on 6 October 2022, we have been summoned, annexure L, page 41, Lordship. They are saying that I've not been suspended.
Wait, annexure?
L, page 41.
Yes. Have been received by the so and so regarding various by so and so.
Therefore, the following GBs are
Yeah,
directed.
so what is wrong? There is an allegation. Are you saying that this extra assistant commissioner has no jurisdiction to have an inquiry of any allegation against you?
Yes, Lordship. Now, the fact remains, Lordship. I've been restrained from functioning as.
Where?
Lordship, verbally, they're not asking, they're asking us not to function. They have taken over all the village functionings, Lordship, the administration.
Okay, Mr. Jimomi, are you restraining them from functioning? We record it.
Lordship, if that's the case, Lordship.
We record it, matter ends.
Yes, Lordship.
So
we
this
will-
order of suspension is
Lordship.
limited only to the council?
Yes, Lordship.
This court is not interfering with the exercise of finding out the allegations, which is there on the basis of which summons have been issued.
Lordship.
They can very well look into it. And they have also not, we take it as an undertaking by the state government or the year for whom he is representing, that the GPs have not been restrained from taking.
If that's the case, Lordship, yes. If they admit that I have not been suspended, yes, Lordship, if the direction.
In fact,
yes.
Lordship, I have said it in my affidavit, Lordship. I have raised a preliminary objection, Lordship. Lordship, the petitioner number one, he has resigned, Lordship, from the post of head GP, Lordship. So whether I have said it in paragraph 2 of my.
Yes, Lordship, I have also stated. But that resignation was done on duress, Lordship. I was forced to. Lordship, in my annexure C, the resignation letter, Lordship, the writ petition, page 28.
So that resignation has been.
With due
accepted.
respect, I would like to forward my resignation from the post of HGB of the Tolosma village on moral ground due to the immense pressure from the group of people. I was forced to.
That is how many people have joined together?
Lordship, altogether there are 7 of them.
Understood, but if it is, you are forced to, it is an independent cause of action. How do you bring all the causes of action together? Anyway, that is another aspect.
Yes, Lordship.
We are not concerned.
And moreover, his resignation has been accepted by the board.
Now, you see, impugn letter, well, let us see annexure M.
Lordship. Oh, Lordship, basically this is a function of the GBs. For distribution of
You know, annexure?
annexure M, page 42.
On the subject, I have to state that as per the deputy commissioner so and so, it is stated EAC will take charge and control over the village council of so and so. Basing on the area, you are requested to make necessary nominating.
This is
someone
how we have been
for
restricted from
lifting and
functioning.
distribution of PDS item meant for so and so at the earliest. Whose duty it is as per the Food Security Act?
Lordship,
Whose duty it is as per the Food
the
Security?
village council, the GBs.
How do you show me?
Lordship, the village council along with the GBs. We are
It
supposed
is
to.
for the village council because the village council now has been taken over by the authority.
Yes, but as far as GB is concerned, Lordship, we have a role.
What is your role? That some role has to be there on papers,
Lordship.
or is it on oral?
No, Lordship, because of the issues of all these impugn letters, Lordship, I have been asked not to take part in these activities.
So what is the duty of a GB?
Lordship, basically, the duty is to for law and order, Lordship, and for interpretation of the.
Let us see what is the duty of a GB.
Lordship, page. Four. Clause 4, page 21, Lordship.
Page 21.
Operation of the purpose fund.
The red
No,
blanket.
No.
This has nothing to do. What is the function of a GB? Gaubura, na?
Yeah, Gaubura.
Gaubura, he will certify whether his age is A, B, C, D. In Assam, the Gaubura's main duty is to certify. Because we have a lot of illegal migrants.
Lordship.
And it is the certificate of the Gaubura which gives them the thing to the effect that yes, he is the age of so and so, I know him, and he has been residing out here for 20 years.
More or less, Lordship, as a practice in Nagaland, they take part in the activities of the village council. They take part, Lordship.
The village council is not composed of there. You take
No,
part
no,
where?
it's not, Lordship, but as a matter of practice.
No,
Lordship.
you take part to supervise the operation of the welfare fund. A board shall be constituted with the commissioner, a chairman, and with the following: a GB representative consists of the president, GB union, and another member.
Yes.
So here, that board is the corpus fund. How it is to be done?
Yes.
Is it the thing that you are not being permitted out there to enter? No. That is not the allegation. So we close it. The instant writ petition has been filed by 8 writ petitioners. You have made allegations against them. So they are taken care of. This court is not touching on the investigation. Then
Lordship, allow me to give my submission. There are certain factual aspects as well as legal aspects in this case to be taken into consideration. My learned friend for the petitioner is saying that their suspension is illegal.
There's no suspension.
That's why, my lord, I'm trying to come to that extent. They have been refrained because there is an allegation against him by the entire village, entire citizens of the village. Since the village was recognized in the year 2012, since then till date, there is no meeting called up by the village council. And they are also part and parcel of the village council because Section 4 of the Nagaland Village Council Act speaks about Nagaland Village Council Act, Chapter 1, Section 4. I would like to take your lordship to this particular section. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages. The same being approved by the state government, provided that hereditary village chief, GPs, and arms shall be ex officio member of such council in charge of voting rights. So this is the fact.
No, lordship, this is pertaining to.
No,
a
Mr.
particular
Council.
tribe.
Mr. Council. As of now, the village council is suspended.
Very much, my lord.
He is not coming for the village council.
The petitioner, do you want to exercise?
How? No, the petitioner cannot exercise any rights in terms with the village council.
Very much, my lord.
Because the village council
I
is
agree.
suspended.
Yes, my lord. I
So
agree.
that cannot be. But the fact that the petitioners have not been suspended is also on fact. What is being suspended is the village council.
Very much.
So let it be. So nothing can be done in respect of the village council by anybody.
Yes.
Neither him, neither or any other person. He is only an ex officio member having a right of voting.
Yes.
But if the main entity is under suspension,
Yes.
so what is the ex officio member going to do?
Yes.
This court is not touching on the suspension of that village council. No,
That's why.
I'm not.
I like
What
it.
only thing is, there is no suspension of the Gambura. So they will be the Gambura. They may be entitled to the welfare fund, or this 5,000 rupees or whatever may be, they will be entitled to. Whatever may be, they will be entitled to. But they would not be entitled to exercise any jurisdiction under the village council.
Very much, very much. So, my lord, here, there is an allegation against the GPs. Why I am standing before this honorable court on behalf of the respondent number 7 to 11 is that they are the respectable persons of the village chosen from the frontal organization of that particular village. And they have raised a voice against the GPs who are exercising their power at their own whims in their own interest. Unabated corruption has been taken place. And if your lordship go through the entire case records of the petitioners in my counter affidavit, from 2012, the village was recognized as a. Now, after that, till the day of filing of the case, despite of the central funding schemes, state schemes, no development, nothing was done. So, one of some.
So, Mr. Counsel, I think we need to see you on a Wednesday when we have a division bench and take it as a PIL. Better off.
No, after all, we
but this is a different aspect. You are not before this court as a petitioner. If any allegation is that, your allegation is that the government is not doing anything against the GB in spite of corruption. Isn't that your case?
Yes.
So take it up with the government. And if the government does not do, file a writ petition, PIL, whichever may be, you can do so. But you are not before this court today.
No, I feel
you have been impleaded by the good grace of Mr. Mujoy, making you as a party. So as of now, nothing is there. So we will be happy if you come. But first, for you to say all these things has to be on the basis where you are the petitioner. That there is a contravention by the government and the government is not doing any action. You can file FIRs of any corruptions or file complaints or do whatever you feel like. But the fact that because they don't come within the ambit of a public servant, so even I don't think 197 any sanction is required. You can very well go under file an FIR or 156(3) or file a complaint against them very well. But the fact remains that you are to exercise that.
Then, my lord, I have a other way of submission. Now, the entire village council has been suspended. For the last, now it's running more than about 1.5 years. There is no village council, no GBs. If the order is to be sustained, passed by the deputy commissioner, saying that the entire village council has been suspended, and the GPs is in part and parcel of that, now they cannot take any activities in the activity
They
of the
cannot
village council.
the GPs have no role now
I agree, my lord.
to
I
do
agree.
anything in the village council, which is under suspension.
Yes. So
they can't do anything.
Yes,
but
my lord. I agree to that.
They will continue to remain as GBs.
So I agree to that, my lord. I agree to that. What this honorable court has observed, I agree to that. But if the village council has been kept under suspension for so many months and years, then how the village will carry on its activity of development activities coming from the central fund, that state fund?
The administration is taking care of under
My lord, let me come to a point. The administration now, as per the
So, Mr. Counsel, we will meet you on Wednesday.
My lord.
On a division bench day. How the developments will happen. It's a subject matter of a
See,
PI.
here, my lord, there is a previous allegation against the GPs. So the entire village revolted against them. They have lost their confidence from the village. Right. They have been.
No, have you? No, you see, these are allegations which are presently under consideration with the government.
Yes.
This court is not saying he has asked for what you call setting aside the summons. This court is not interfering with that. So they will go ahead. If they find that yes, there is some corruption, they can resort to such action as permissible under law. This court is not doing anything as regards the summons.
Yes.
And Lordship, a committee has been constituted
My lord,
to look
here,
into the allegations.
The grievance faced by the general public of the village is that there is an inquiry to be conducted by the state government against the GPs as per the allegation. But for so many months, no step has been taken. Whether the GPs are involved or not, that is different aspect. But now, due to suspension, the villagers cannot go ahead with any activities. That is the problem we are facing. So I also filed in IA in this case, IA 69, which may be taken into consideration at the time of the disposal of this writ petition also.
IA 69, I'll pass an order. Nothing requires to be passed in view of the judgment.
So my humble prayer before this honorable court.
Okay, let me finish up this before 1 o'clock. Yes. 8 petitioners have joined. 8 petitioners who are functioning as Gamburas, bracket GB, have joined together to file the instant writ petition, challenging the order dated 31/5/2022 insofar as it relates to temporarily suspending the services of the petitioners as Gamburas of Tolazoma village, semicolon. The order dated 26/7/2022, whereby the petitioners have been directed to hand over all the records of the village, semicolon. The summons dated 6/10/2022, directing the petitioner to appear before the extra assistant commissioner, Kohima, Nagaland, semicolon. Letter bearing dated 7/10/2022, whereby the nomination of the distributor for PHS and PMJKAY ration of Tolozoma village, as well as seeking a direction upon the state respondents to allow the petitioners to function as GBs of Tolozoma village in view of their appointment. The full facts apparent on the records All the petitioners, na? All the petitioners have been.
Yes, Lordship.
All the petitioners were appointed as GBs of Tolazoma village.
Lordship.
On the basis of orders issued by the Deputy Commissioner Dimapur
On the approval of the government, Lordship.
the basis of orders asked by the deputy issued by the Deputy Commissioner Dimapur.
Lordship.
First, it is also on record. It is also mentioned in the writ petition that the petitioner number 1 was promoted to the post of head Gaubura, head GB. But however, on 21/4/2022, he had resigned from the post of head Gaubura of Tolazama village on moral grounds. From the materials on the record, it further transpires that on 31/5/2022, the Deputy Commissioner Shumugudema on account of various allegations being made against the village council of Tolazoma as well as the Gamburas, had suspended the Tolazoma Village Council and its subsidiary bodies such as the Village Development Board Management Committee until further orders in terms with Section 22 of the Nagaland Village Council Act 1978. This order has been impugned in the instant proceedings. By the petitioners on an assumption that the petitioners who are the GBs have also been suspended. The record further reveals that on 26th of July 2022, the extra assistant commissioner had passed an order on the basis of the order of suspension of the village council Tolazoma dated 31/5/2022 and directed all concerns, including the head GB, that all registers, records, cash books relating to VDBMC, communitized bodies such as SMC, Watson, WATSAN, VEMB, VHC, etc. So it should be submitted to his office on or before 28/7/2022, failing which necessary action would be taken against the defaulting individuals. This order have also been essayed in the instant writ petition on the ground. What is the ground?
Lordship,
Why are you assailing this?
with regard to this order, Lordship.
Yes.
Lordship, here a copy has been issued to me with regard to all any document that is with me. With regard to the
No,
official-
no. Are you having registers, records, cash books of these
No, we don't.
have been essayed on the ground? That the said order has been marked to the head GB.
Lordship.
Although the petitioners are not in possession of any register, records, cash books relating to BMC, communitarized bodies such as SMC, Watson, Web, VHC, etc. It is also seen that the extra assistant commissioner, Setikema, Nagaland, had issued a summons on 6/10/2022 to 7 of the petitioners to be present in person seeking clarifications on the basis of the complaint received by his office on 13/10/2022 to answer for clarification at his office on 13/10/2022 in respect to the complaint filed by the Tolazoma villagers. This summon have been assailed in the instant proceedings on the ground. What is your ground?
Lordship.
What is your ground for assailing?
Lordship, we have been asked to appear in person.
So
to the allegation made, Lordship. Now, as Lordship has pointed out, Lordship, we are not part and parcel. We do not involve in the activities, Lordship, but we form a part and parcel of the village council. And there's allegation against us. So
you
someone
want any order to be passed in your absence?
Lordship.
You want any order to be passed by these authorities in your absence?
No, Lordship.
Then you will come tomorrow. If summons is not issued, you will come tomorrow and say principles of natural justice have been violated.
Lordship.
This summon has been assailed in the instant proceedings on the ground that the allegations made against the 7 of the petitioners are absolutely baseless. The petitioners have also challenged the order, the directions, the communication dated 7/10/2022 issued by the director, Food and Civil Supplies to the extra assistant commissioner, Setikama, whereby the extra assistant commissioner was requested to make necessary arrangements in nominating someone for lifting and distribution of PDS items meant for Tolazama village at an early date in order to avoid lapses in the distribution in view of the fact that the deputy commissioner had suspended the Tolazama village council by the order dated 31/5/2022. The reason for assailing the said document, said direction, is that if a nomination is given to any other person, the petitioners who are the Gaunguras, why are you assailing this?
Lordship, because we are responsible for distribution of this items, Lordship. along
The
with
said communication has been put to challenge in as much as it is the case of the petitioners that the Gamuras are responsible for the purpose of distribution, for lifting and distribution of the PDS items, and as such, making any other nomination amounts to taking away the rights of the petitioners. Remaining, I'll come back.
Lordship. I mean, those specifically. And other day of.
Hello. Hello. Hả? Oh, mà cái con của này này read the video này rồi đấy. Sao rồi làm cái gì vậy?
May it please your lordship. If my lord may kindly allow me to place a request for your lordship's consideration. The part heard supply list, if my lord may kindly give preference to.
Yes, yes.
the matter.
After I finish up this, I don't think many matters are there. Admission I completed, then I'll take that part.
Lordship.
Yes.
My lord.
Yes, Mr. Takama, sir.
After completion of the admission.
Yes.
Okay. Your lordship, I beg to mention hearing at number 40. Because
No,
of
I
the-
think that partner will take the date. And I would not
maybe
like
the
to
list-
detain the
next week.
earlier, all other lawyers in this cold wintry day.
Your lordship, I have taken the counsel of the other party. And definitely today it may not reach because of the paucity of time. So the matter will be released next week, any date. Monday.
Okay, you take the dates from him.
On Monday.
Okay. All other
Okay,
matters,
yes.
I think after the completion of the admissions, I'll take up the partner. And then thereafter, I would not be taking any other actions. This will take,
So
because I'll
item
dictate
40 on Monday, Your Lordship, as a fixed item on Monday.
as you wish. I'm, whenever you want.
All right.
Yes, madam, what was the last thing I said?
Are responsible for the for lifting and distribution of items and as such making any other nomination amounts.
Okay. Pursuant to the filing of the instant writ petition on December 15th, 2022, this court issued notice on 27/1/2023. The record reveals that the respondent numbers 1 to 6 have filed a joint affidavit in opposition raising preliminary objections and also supporting the stand of the district administration in issuing, in passing the impugned orders, in passing supporting the impugned orders as well as in supporting the actions of the district administration. It has also been mentioned that an inquiry committee has also been set up to investigate and review the matters on several issues with regard to the mismanagement of village funds and to ascertain as to whether the village authorities have adhered to the village, what is that full form? VDB Model Rules 1980. What is VDB? Village District
Village Development Board.
Village Development Board Model Rules 1980.
Yes.
Further to that, it has also been mentioned that the petitioner number 1 has voluntarily submitted his resignation letter to the authorities, which was also accepted by the state respondents. Therefore, on the basis of the said averments made in the affidavit in opposition, it was categorically contended that no legal rights of the petitioners have been infringed. The record further reveals that there is an affidavit in opposition filed by the respondent number 7 to 11. Wherein it has been mentioned that the petitioner number 1, 4, 7, and 8 were appointed as GBs on 15/3/2015 after the Tolazoma village was officially recognized by the state government. The petitioner number 1 had submitted his resignation on 21/4/2022 on moral grounds. The petitioner number 7 had also submitted his resignation on 2/11/2022 on account of his old age. Under such circumstances, the petition number 1 and 7 cannot be a party to the petition.
My lord, just to interfere.
It has also been mentioned in the said affidavit in opposition that the petition number 6 and 7 were appointed as GB in the year 2017 and 15 respectively. And during their tenure, the said petitioners have failed to discharge their duties. It was also mentioned that the said petitioners are no more residing in the village. It was also mentioned that apart from the petitioner numbers 1, 6, 7, and 8, who had no authority to file the, who had no locus standi to file the instant writ petition, the petitioner number 2, 3, 4, and 5 no longer enjoys the confidence of the villagers, inasmuch as they have utterly failed to act as the village head in discharge of their duties to the satisfaction of the populace of the village. Further to that, in the said affidavit in opposition, it has been categorically mentioned that it is at the behest of the respondent number 7 to 11 and the villagers of the various villages, the respondent authorities are taking action, and as such, no interference is required from this court.
My lord, Para 7 of my affidavit, there is a serious issue which may be taken up by this honorable court also. Para 7.
In the
page-
backdrop of the above submissions, in the backdrop of the above pleadings, the record further reveals that the petitioner had filed replies
Yes,
to the affidavit in opposition filed by the respondent numbers
7 to 11.
7 to 11. In the backdrop of the above pleadings and the materials on record, this court have also heard the learned counsels appearing on behalf of the parties and have given their anxious consideration to the submission so made. It is seen from Annexure A, which is a notification dated 9/4/2010, whereby the governor of Nagaland was pleased to notify the rules for appointment of the Gaumburas and operation of the Nagaland Gaumburas welfare scheme in the state of Nagaland with effect from the date of the said notification. The said notification mandates the qualifications required as well as the disqualifications which would as well as the disqualifications. The entitlement of the Gaumburas is also spelled out in clause 2 of the said notification. Clause 4 of the notification stipulates as to how the corpus fund is to be operated. And in terms with clause 5, a board is required to be constituted to supervise the operation of the welfare fund. Amongst the various persons, members to be members of the said board, it shall include 2 Gaumburas, of which one should be the president of the Gaumbura Union. In the backdrop of the above, let this court therefore take note of the impugned orders as well as the communications. By the order dated 31/5/2022, the Deputy Commissioner, Chumike Dema, on the basis of the complaints made against the Village Council of Tolozoma, as well as the Gaumburas, had suspended the Tolozoma Village Council and its subsidiary bodies such as the Village Development Board Managing Committee until further orders in accordance with Section 22 of the Nagaland Village Council Act 1978. The petitioners herein are admittedly only the Gaumburans. The Village Council has not approached this court challenging this order dated 31/5/2022. In this backdrop, let this court take note of that what is the role of a Gaumbura in a village council. Section 4 of the Nagaland Village and Area Council Act 1978 stipulates that the hereditary village chief, Gaumbura, and arms shall be ex officio members of such council and shall have voting right. Footstep. The above, the said notification, said order dated 31/5/2022 under no circumstances suspends the Gaumburas. However, their rights have been duly curtailed in view of the village council in question having been suspended. Taking into account the allegations which have been allegations on which the order dated 31/5/2022 has been passed, this court is not inclined to interfere with the said order, that too at the behest of the petitioners who are only Gaumburas. Now coming to the order dated 26/7/2022, the said order is an order on the basis of which is consequential to the order of suspension dated 31/5/2022. Inasmuch as by the order dated 31/5/2022, the EAC Sentikema was directed to take charge and control of the village council of Tolozoma village. Under such circumstances, the EAC Sentigema had directed all concerned to submit the registers, records, cash books relating to the VDBMC, commuterized bodies such as SMC, Watson, VEM, VHC, etc. Full stop. It is the specific submission of the learned counsel for the petitioner that the petitioners are not in possession of any of these documents. Full stop. Therefore, in the opinion of this court, the said order dated 26/7/2022 does not require any interference, more so in view of the fact that the said EAC Sentigama has been directed to take over the charge. In the backdrop of the above, let this court therefore take into account as to whether the issuance of the summons by the extra assistant commissioner Sentigama, Nagaland requires any interference. The petitioners herein were admittedly appointed as Gaumburats. There are serious allegations which have been made by the people as regards the functioning in the post of the Gaumburas by the petitioners. Under such circumstances, in the opinion of this court, the issuance of the summons by the said extra assistant commissioner Sentigama to the various petitioners does not call for any interference. However, this court observes that if any orders have been passed prejudicial to the interest of the petitioners thereupon, upon completion of the inquiry, the same shall be subject to such proceedings as is otherwise available in the law. This court also finds it pertinent to take note of that in terms with the Food Security Act, National Food Security Act 2013, as well as the rules frame therein under, the rations, the distribution of PDS is being made by the PDS is being made at the behest of the central government through the state government and its functionaries. The petitioners herein though challenges the said communication on the ground that their rights have been affected inasmuch as the Director, Foods and Civil Supplies, Nagaland, have requested the extra assistant commissioner to provide nomination to whom the nomination of some person for lifting and distribution of the PDS items. The petitioners herein have not been able to show before this court that they have been entrusted by any order or notification for the purpose of distribution, lifting and distribution of the PDS. Under such circumstances, the question of interference with the said communication dated 7/10/2022 does not arise. Consequently, this court finds no reason for interference with the impugned orders as well as the communications. Be that as it may, this court, however, observes that the petitioners except the petitioner number 1 and 7, 1 and 8, who have resigned.
Yes.
1 and 7.
1 in 8. Then, my lord, just to enlighten this honorable court, during the pendency of this case, one of the petitioner has also been expired, which has not been brought to the notice of this honorable.
Who has expired?
I've never been informed.
It's okay. Petitioner
Petitioner number 3.
one and the last line what they said, be that as it mean.
This court, however, observes that the petitioners accept the petition.
And the petitioners accept the petitioner number 1 and 7 continues to be the Gamburas of the villages wherein they have been duly appointed till their appointments have not, till they are discharged or terminated in accordance with law. During the course of the hearing, Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 7 to 11, however, submits that during the pendency of the instant petition, petitioner number
3
had expired.
And my lord, another aspect, petitioner number 8 is not a resident of the village.
No, that is okay. That is for them to take votes. The petitioner number 3 had expired. Under such circumstances, the declaration to the effect that the petitioners herein continue to remain as the Gamburas shall not be extended to the petitioner number 3 who had expired. With the above observations and directions, the petition stands disposed.
My lord, for the sake of justice, if this honorable court can give an observation to the caretaker, otherwise to the state government, that the new team of the office periods of the village council to be constituted as early as possible, because since the inception and recognition from 2012, 10 years has been passed. The tenure is only for 5 years, and there is no village council. So by the caretaker, it will be difficult to carry on the administration of the village without any definite period. So for the ends of justice, my prayer before the honorable court is that this court will give an observation to the state government to form a new team.
No, Lordship.
Village council.
Inquiry has to be conducted. And if I am found guilty, yes. But if they don't find any fault of me, Lordship, where is the question of forming an interim body? Lordship may give a direction for expeditious disposal of the inquiry.
Interim body does not arise.
Yes.
And Mr. Counsel, I don't want to make you lose one more brief. You come up with a writ petition that after so many years also they have not done anything. Then this court can pass appropriate directions. Don't you think so? This court, you see, kindly appreciate one thing. This court is limited to only the cause which is placed before this court by him. If I transgress beyond that, an appellate forum is there for that, and the entire judgment becomes useless. You challenge it.
For admission, item number 19.
Yes, Mr. Takama, sir.
Lordship, the pleadings are complete, so the matter can be considered.
Okay.
Lordship,
this is matter pertains to?
my lord, the issue relates to, my lord, I am aggrieved by the expeditious action of the respondent authorities with regard to wrong fixation of my seniority, the date of regularization. Lordship, kindly grant me 5 minutes. I will highlight the facts in 5 minutes.
Okay.
Lordship,
this is for the date of regularization.
date of regularization. Lordship, kindly allow me 5 minutes. Within 5 minutes, Lordship will I can complete the facts of the case. Then I will refer to the documents. My lord, I was appointed on ad hoc basis as a graduate teacher on 12/3/1993 and continuing service for the last 31 years as a graduate teacher. Ad hoc. Now I'm regressed. Worship, the state government came out with a policy. Cabinet took a decision
to come up with a regularization scheme for those who have completed 5 years and 10 years of service. And the decision was taken on 16/1/2004 that those who have completed 10 years of service as on 16/1/2004, if there's a substantive vacancy, requisite qualification in satisfactory service, he can be straight away regularized without a screening test. That was the first criteria. For the second criteria, those who have completed 5 years of service, continuous service, as on 16/1/2004, subject to the three conditions, to the screening test, you will appear for a screening test. If qualified, then you will be also regularized. Accordingly, an office memorandum was issued on 18/2/2004. On the basis of the decision of the cabinet on 16/1/2004. Lordship, this is prior to Gauhati. Then, my lord, my case also was recommended because, Lordship, I was appointed on 12/3/1993. So by 16/1/2004, I have completed 10 years of continuous service. So all similarly situated persons, along with the petitioners, were recommended for consideration on the basis of the scheme. Others who are similarly situated persons, 183 persons were, Lordship, regularized on the basis of the scheme who had completed 10 years of service with effect from 16/1/2004 in the year 2006. And also, Lordship, those who had completed 5 years of service, my juniors, as of 16/1/2004, they were also regularized, my lord, on 16/3/2012 with effect from 16/1/2004. That is the date of decision of the cabinet. In fact, Lordship, initially, regularization order was issued for 183 from the date of initial appointment. Then he changed it to the date of decision of the cabinet because, my lord, after the screening days, it was put up before the cabinet again for approval. So, my lord, on the second day, order was issued from the date of decision of the cabinet. Then subsequently, Lordship, he was regularized with effect from 16/1/2004 by similarly situated person of 10 years.
But not the petitioner.
Not the petitioners. And my juniors also, who had completed 5 years as on 16/1/2004, they were all regularized with effect from that 2004. I was left out. I submitted representations. Then, my lord, however, my lord, I was regularized by an order dated 5/7/2010 with effect from 18/5/2010.
Where? Where's
My
that
lord,
order?
Lordship,
5 July.
Lordship, which
Yes,
is. you will
page
find-
37.
Page 37.
Yes.
That is from the date of cabinet decision.
Okay. So you have been regularized as on 18/5/2010.
Yes, Lord.
Whereas you should have been regularized from 16/1/2004.
That is the issue.
Yes.
Then, my lord, I have submitted 3 representations. Thereafter, my lord, the principal director, my lord, the principal director had forwarded my case for consideration, my lord. And my lord, which is, kindly allow, Lordship, kindly allow me to.
Page 42.
My lord, page
42.
Page 90, Lordship.
Page 90. What is page 42?
Lordship, kindly do it immediately.
To page 42.
My lord, page 42 is with regard to the persons who had completed on
5 years of
5 years of
continuous service as on Iman are hereby
16/1/2004.
regularized under the following term. The effective year will be 16/1/2004.
Yes, then my lordship will find 10 years of service at page 26.
Then you are saying about page 19, huh?
Page 90 is the forwarding letter of the director, principal director. Page 90.
So it should be as per 16/1/2004.
Yes, now my lord, in spite of the recommendation of my case by the director, principal director on 20th April 2023, till date the respondents authorities are sitting over it. That is the crux of the issue, lordship.
And now you have retired.
No, I'm in service.
You have retired?
No, I'm still in service.
You're in
I'm still in
service?
service.
Okay, so this is okay. No, why are you saying about the pension in your matter?
No, my lord.
Oh, there's no pension, no? So,
My lord,
so you are to be given as on 16/1/2004.
with all consequential benefits.
With all consequences.
Also, lordship, you kindly take into consideration that on completion of 10 years of continuous service, with effect from the date of initial appointment, I was granted.
Whereas others have been given and not you.
Yes, that is the only issue. Now, my lord, lordship, you kindly allow me to show the regularization scheme at page 24.
Yes.
Married, my lord. The government of Nagaland constituted a committee dated 4/2003 to examine the issues relating to a large number of ad hoc contract employee appointed in the post in various.
Madam AAG, is yesterday's matter na
Yes,
Division
yes, yes.
This is 18/2004 that regularization
Yes,
was
yes.
given.
Yes,
Where there was a direction and appeal
Yes,
filed and all.
yes.
Okay. This is one.
No more in existence, this one is no more in existence, your lordship.
No,
Because
not
this has
now,
been
not now.
No,
Because the direction which was given there,
Yes,
that
yes,
is why
yes.
you filed the review.
yes, lordship.
And that was only for, this is for teachers, ad hoc appointments. Okay. Okay.
It is for all government servants, lordship. But
I
was
am actually
regularized on the basis of
new,
this.
new with these memorandums.
Yes,
So
lordship.
yesterday a matter came up with this 18.2. I was just thinking how, I've only heard about regularization under 22.9, 17.3, and what is 18.2?
Yes.
So this is it, okay.
On the basis of the recommendation of this committee, a set of measures to be taken to deal with the existing situation and to prevent recurrence of such appointments in future was placed before the cabinet, which was considered and approved by the cabinet on 16/1/2004. In pursuance of this decision, the government of Nagaland is pleased to order as follows. One, all fresh cases of ad hoc contract appointment will be taken in accordance with PNR department dated 16th February 2001. So such appointment will be made, and such appointment will be made without following the revised procedure laid down in the aforesaid memorandum. All the appearing authorities will take advanced action to fill up the anticipated vacancies by following the prescribed procedure and avoid a situation where the extraordinary measures of ad hoc contract appointments has to be resorted to. In the respect of the existing ad hoc and contract employees, the following action will be taken. Category 1, ad hoc contract appointments made against section post. A, employee having more than 10 years of service. An employee of this category may be considered for regularization provided 1, there is a sanction post. 2, the employee fulfills all the eligible criteria for the post, including the requisite educational qualification. The performance of the employee has to be satisfactory in the service. The concerned department will submit specific cases to the government for approval of obtaining the recommendation of a screening committee with the following composition. Then notion may kindly come to B. Employee having 5 to 10 years of service, an employee in this category will be considered for regularization provided in addition to the above mentioned 3 criteria, namely there is a sanction post, the employees fulfill all the eligibility criteria for the post, including the requisite educational qualification.
So the criteria seems to be same for 10 years and
examination. Next, the sub
Ah,
an
to the
examination,
test suitability.
written or viva voice to test your suitability should be organized by the concerned department under the administration of the Administrative Training Institute. Qualifying marks should be laid down in advance, and only those who qualify such screening days should be considered for regularization by following the procedure as mentioned in 3A. So for 5 years to 10 years, there has to be a written test. No. For 10 years and above, 3 criteria there should be sanction posts available, educational qualification, satisfactory performance, satisfactory performance.
So as regards Mr. Takavasa, as regards the sanction post, there was availability.
My lord, there was available. I was appointed against a sanction post.
At that point of time.
Yes, and lordship.
Let's see your appointment order.
Yes. Now, my lord, before I go to the appointment order. Lordship, kindly allow me to make a clarification here. On page 24A,
Against, and page 18
Yes.
is Annexure A,
Yes.
against the,
Madam,
against.
page 19 is a type copy. May I
Transfer.
read type copy, page 19? Will be more clear. Type copy of page 19. Mr. Rakesh Ranjan, DSC PH, is hereby appointed on ad hoc basis as a assistant teacher, creative teacher at middle school Tanhai under the establishment of deputy inspector such and such, plus an interline compensatory allowance of basic pay with all other allowances at the rate prescribed by government of Nagaland from time to time with effect from the date of training up to 3/4/1993 against Mr. T. Shetty, assistant teacher transferred.
No, so if it is a transferred, whether the post doesn't go, whether the sanction does not go there.
The normal procedure under government service, a person is not transferred with post. That is a normal procedure.
But that is not the procedure as per law.
And lordship, as per the law, and also lordship, once it is transferred, I read the capital statement of the petition that this gentleman was not transferred with post.
No, you see, a post, if it is a person is being transferred.
Yes.
The post goes with him.
No.
Yes, that is the law.
My lord, the substantive post remains.
The post remains, but you see, as per the creation of the post, 100 posts are being created, of which, just for example, a person who is holding a substantive post A, if he is transferred to a place somewhere in X.
Usually, lordship, when the transfer is made, transfers are made against vacancies. Mr. A is transferred out. Against that vacancy, Mr. B goes, and Mr. C will come to Mr. A post. That is a normal procedure because, lordship, if there is a creation of post and a person is appointed there, then the moment post is created, then my lord, vacancy, then the substantive, then he goes there. But in a normal transfer, lordship, against existing vacancy, he transfer from one place to another. Teachers or in the same rank of deputy commissioner, director, whatever, inspectors. So, my lord, the vacancy, against vacancies, people are transferred. Against a non-existing vacancy, people cannot be transferred. One. Secondly, lordship, going by your lordship's argument that there is no substantive vacancy when somebody is transferred out. Let us go by that worst position. Even in that situation, lordship, if I go by the affidavit of the government says you were able to adjust a substantive vacancy for me only in the year 2010. That's why I was accommodated. I was regularized only then. That is the stand of the government. Now, my lord, in my reply affidavit, what I have been submitting is that I was appointed in the regular scale of pay in the year 1993 without any break of service. I am continuing till date. So, if it is a case of even going by the government's position that the substantive vacancy has to be adjusted for those who have completed 10 years or 5 years. My lord, why not? Why the vacancy was not substantive vacancy, even presuming and admitting by that argument, why not the substantive vacancy was not adjusted in order of seniority? My juniors.
Or for the matter, 5 to 10 years, if somebody has to do, he has to pass an exam.
Yes.
And thereupon he has to again go back to 3A.
Yes.
Whereas you had completed 10. So if those people are there and 3A1 only says that there has to be a sanction post.
Yes, so the issue is when the examination was conducted for those people who have completed 5 to 10 years of service, substantive vacancies were already there. In view of the availability of the substantive vacancies, the examination was conducted. That is the issue, Lord. Now, my lord, thereafter, lordship may kindly come to page 27. In terms of the office memorandum, my lord, my case was recommended since I had qualification. May I read page 27 of it?
Yes, 27 is for,
To the director, submission of original documents in respect of ad hoc graduate teacher for DIS mod. With reference to your letter dated 24th May 2004, I have the honor to submit herewith the original documents in respect of ad hoc graduate teachers under the establishment of DIS duly filled the performer for 5 years and above ad hoc graduate teachers for regularization of their service. And my lord, my name appears as still number 11.
yes.
So it shows that my lord, one of the controlling officer had recommended my case for regularization in terms of the scheme.
So you were put in this 5 years bracket.
No, my lord.
Under-
Lordship, 5 years in our lordship may kindly see for regularization for lordship may kindly see from serial number 1. Serial number 1, all those 5 years, 5 years to 10 years, he recommended together lordship. Mr. Datta, who was appointed 91, and my lord up to 11. My lord up to 15. Up to 15, all of us have completed 10 years and above as of 2016 or 2004. And the rest below, lordship you kindly see at page 29.
15. From 16 onwards.
Yes, lordship you kindly see the observation of the from 16 onwards, lordship are 5 years and above. My lord, the lordship you kindly see at page 29. Serial number 18, 19, 20, they have been serving as ad hoc teachers for 5 years running since their local and backward region, and hence since their case may kindly be considered on ground of backward tribe reservation. So my lord, 5 years and 10 years were all recommended together because my lord scheme is one. Now, besides, my lord, lordship also may kindly appreciate this fact that my lord at page 20, lordship at page 20, since I had PH at the time of initial appointment, I was given 2 advance increment at the time of my initial appointment at page 20 and actual B, lord.
Yes.
Then my lord, page 22. My lord, the type copy is page 23. Type copy will be more legible. May I read page 23?
Okay. Page 22.
Yes, page 23.
Yes.
Having completed 10 years of continuous service, the following teachers under the establishment of Deputy Inspector of School Moon are hereby granted senior skill of pay as mentioned herein. My name appears as serial number 5. My lord, effective date is 12/8/2003. Serial number 8. Page 23 of it.
So, Mr. Takama, sir, you want a similar order like page 36?
Yes, Lord. The issue is, I'm trying to show that only because I was holding a substantive post, I was given one of senior skill of pay with effect from my date of initial appointment at page 23. I'm trying to show the continuity. Because my lord, senior skill will be granted.
The past service rendered will be counted for all other benefits such as increment, leave, pension, etc.
Yes.
Here in your order of this, it has been, the interview will be fixed in the order of date of joining the post as graduate teacher.
Well, can you allow me to highlight this fact? Because I need to highlight certain issues to clear the confusion. How government has taken the decision. Now, Lordship, can you allow me to refer to, my lord, page 32. Similarly situated persons, how they have done it. This will clarify the issue. My type copy page 33. Page 33, my lord, is the type. In pursuance of the Government Approval dated 13/1/2006, the following 183 teachers as per Annexure A, who have completed 10 years of continuous service as on 16/1/2004 are hereby regularized with effect from the date of joining into service. So, my lord, that was the first decision, that you will be regularized not from 16/1/2004, but with effect from the date of initial appointment. That was the initial first order passed. Then, my lord, Lordship, this was superseded.
So you want your, Mr. Takaman sir, how are you being affected? Understand, 16/1/2004 should have been taken, no, it should have been taken from 1993.
My lord, that is what I'm trying to show, how the government has taken this. Then secondly, Lordship, on the page 35. And then I will show, I need to show 3 documents so that it will clarify your Lordship's queries. Page 35. In supersession of page 33, my lord, page 35 was issued again for the same people. The department order number dated 30 November 2006 hereby stands cancelled, and in pursuance of the government approval order dated 13 November 2006, the following 183 teachers who have completed 10 years of continuous service as on 16 January 2004 in Boots are hereby regularized with effect from 16/26/10/2006.
Now, Mr. Takaman, tell me, out here in Nagaland, you have a new pension scheme or old pension scheme?
Well, now, old pension as well as new pensions are.
What is the effective date for new pension?
Well, Lord, I need to confirm, what is the date?
Because this will have an impact. Any
But
declaration
I
given
come
will.
I come within the old pension scheme.
How? If you are regularized,
Yes.
the moment you are regularized, you are brought into the scatter of the government.
Well, Lord, I'm already regularized. The only issue is the question of date.
Understood. Therefore, if the regularization dates back
Yes.
to 16/1/2004,
My lord.
then in that case, you'll be, I don't know what is the date of the cutoff for the pension.
My lord, that I need to confirm with you, what is the cutoff date?
Because in central government,
My lord, I'm told.
is 1/2/2004.
Somewhere in the year, one of the subject to confirmation, I'll confirm, but it is 2010. From 2010, subject to confirmation, the new pension scheme is applicable for the petitioners.
There is no problem.
There's no problem. Now, why I'm referring to the 3 documents, the manner in which Lordship, page 35. Page 33 was superseded by page 35. Now here, those who were my 10 years of service, page 33 says date of joining into service. Now it was changed into 26 October 2010 with regularized with effect from 26/10/2006. The next paragraph. This has the clearance of pioneer dated 26 June 2006, concurrence of Finance Department 31st July, and this is the issue, important, and cabinet approval 26 October 2006. The industry seniority shall be determined fixed as per the date of approval of the cabinet, that is 26 October 2006, and the date of legalization. Now, what has happened, Lordship? After the scheme, after they are screened out, their names are again put up to the cabinet for approval. So the date of approval was 26 October 2006. So accordingly, page 33 was superseded by page 35, giving date of 26 October 2006 as which is the date of cabinet approval. Then it was further superseded at page 36. Now at page 36, Lordship, it is back to 16/1/2004.
You want that?
Yes, I wanted that. Now, Lordship, may kindly come to page 37, which I'm praying for review.
Yes.
In pursuance of the government approval order, such and such,
and 18 teachers listed in Annexure A who have completed 10 years of continuous service as on 16/1/2004 are hereby regularized under the following terms and conditions. The effective date for regularization will be with effect from the date of definite approval, that is 18 May 2010. The past service shall be counted for other benefits such as employment, leave, pension. The university security will be fixed in order of date of training as graduate teacher. Now, my lord, 18 May is the date of cabinet approval. So, my lord, this is similar to page 35, which was superseded by page 36.
So what is the effect of your interstate seniority going up?
My lord,
You'll be
now,
promotion.
my lord, I am even junior to those persons who have
joined after
completed
5
5 years of service as on 2004. They are already promoted to assistant headmaster. My batchmates are already, most of them are now some are headmasters on the verge of becoming headmasters. I am still a graduate teacher for the last 31 years, serving in the most inferior list. Now, lordship. So that is the crux of the matter. That there is in that lordship will kindly appreciate this fact that I am challenging the I am challenging the general administrative action of the government, which is contrary to the scheme and clear violation of 14 and 16 wrong application of date. Lordship.
No, Mr. Takamaza, I am convinced with your case. There's no worry on that. But I'm only thinking or pondering out here that if I pass an order in your favor now,
yes,
what are the consequences
I am coming
which
to
will
that.
fall upon others?
I am coming to that point.
Yes.
Lordship, I have taken care. I have what you compare. I thought that is why I am coming straight to the point. Lordship, the respondents, government had objected on 3 terms. Non-joiner of necessary party.
Huh?
Non-joiner of necessary party. I am coming to that point. To address this issue, non-joiner of necessary party, delay, and thirdly, that in the initial appointment, I was not appointed in cases of stated vacancy. These are the 3 grounds taken by the government. So there only I am trying to address because that will, I am sure, my lord, that may address lordship's concern. Now, my lord, on the issue of non-joiner of necessary party, I'll come straight to the point. Can you allow me to refer judgment? That would make cover my. This is making a long submission, okay? 1974 for SCC 335. I have submitted one of these documents already.
335.
Yes.
1974?
My lord, 1974 for SCC.
Oh, 4 SCC. 335.
This is quite similar to my case. Very my lord.
Just 1 minute. Yeah, very good.
Can you allow me to read paragraph 2, then I'll move so that lordship will understand the facts of the case. Respondent number 1 to 9 in civil appeal made a petition under Article 226 of the Constitution in the High Court for issue of a writ of mandamus directing the present appellants to fix the university's immunity of the writ petitioners as per original proceedings, that is, dated 16 October 1952 of the Railway Court, and will further direct them not to give effect to the subsequent court proceeding dated 2nd November 2, 1957 and January 13, 1961 of the court issued by way of notification in clarification of its earlier proceedings of 1952. Then lordship may kindly come to page 11.
Page?
The paragraph, I'm sorry, paragraph 11, page 3 forward.
Preliminary objection.
Yes. Mr. Such and such, counsel for the appellants has raised two preliminary objections. The first is that the writ petition was filed 8 to 11 years after the issuance of decision, as such that it's liable to be dismissed on the ground of laches. Second is that writ petition did not include about 120 employees who were likely to be affected by the decision. In this case, those employees whose seats arguments were necessary parties and their non-tender is fatal to the petition. Then Lordship may kindly come to paragraph 11. Then my Lordship may kindly
Paragraph
sorry,
15.
paragraph 15. I'm sorry, paragraph 15. I'm sorry, paragraph 15. My Lord, as regards near paragraph 15, as regards the second objection, it is to be noted that the decisions of the Railway Board in even in the writ petition contain administrative rules of general application regulating absorption in permanent departments, fixation of seniority, etc. of the employees of the erstwhile grain shop departments. The respondents petitioners are impeaching the validity of those policies decision on the ground of being violative of Article 14 and 16 of the Constitution. The proceedings are analogous with those in which constitutionality of a statutory rule regulating seniority of the government's revenue is the same. In such proceedings, the necessary parties to be included are those against whom the relief is sought, and in whose absence no effective decision can be rendered by the court. In the present case, the relief is claimed only against the railway which was included through its representative. No list or order fixing the petitioners to service the particular individuals pursuant to the income decision is in challenge. The employees who are likely to be affected as a result of the readjustment of the petitioners in accordance with the principle laid down in the Board of Decision of the were at the most proper parties and not necessary parties, and the non-tender would not be fatal to the writ petition. Then Lordship, you kindly allow me to read 20, paragraph 20. 20 and 21, 20, 21 and 22.
Yes.
The fundamental right, the fundamental right of equality means that persons in the like situation under like circumstances are entitled to be treated alike. The constitutional code of equality and equal opportunity observe this in such and such is a charter for equals. So long as employees similarly circumstances in the same class of service are treated alike, the question of hostile discrimination does not arise. The equality of opportunity for purposes of seniority, promotion, and like matters of employment is available only for persons who fall substantially within the same class or unit of service. The guarantee of equality is not applicable as between members of distinct and different classes of the service. The Constitution does not command that in all matters of employment absolute symmetry be maintained. A wooden equality as between all classes of employees regardless of qualifications, kinds of jobs, nature of responsibility and performance of the employees is not intended, nor is it practical if the administration is to run. Indeed, the maintenance of such a classless and undiscerning equality wherein really.
So your seniority position as of now is half.
Lordship, then Lordship, you kindly allow me.
You should have been at 489. Now you are at 970.
Yes, yes. But Lordship, you kindly appreciate. Deal with it. Yes, I am in service for the last 31 years. No final seniority has been published. The final seniority list was published. It is soft today's people are to Supreme Court. So, as I today, that is one. Now, Lordship, I am not impugning any seniority list. I am not challenging the official promotions of my juniors. My Lord, I am only challenging the arbitrary actions, administrative action of the respondents in violation of Article 14 and 16, contrary to the Office Memorandum of 2004, which has laid down the policy. I am confining to that. So, my Lord, my respectful submission, my case is covered. 920 is protected by paragraph 50 of this case. Because in this case also, my lord, they have only challenged, they have only made a direction that whatever decision has been taken by the government, the report to be implemented. And the subsequent the report resolution, which was adverse to him, not to implement, and he did not implement the 120 respondents.
But Mr. Takamasa, one other thing is, how do you take care of the situation? Understand you have a case. How do you take care of the situation that along with you, many others have also been regularized? As could be seen out here.
Yes.
Why I'm saying this is relevant. In this particular,
Yes.
yes, kindly see at page 83.
Yes.
These persons from 966 to 975.
Yes.
These people have been regularized and given the date on the basis thereof. Whereas all these people are exactly similarly situated with you. Now, how do you take care of a situation that because of the petitioner, I put him to there, whereas what will happen to the others?
All these years, I am the only person who has been consistently pursuing this court, and I approach this honorable court. I am the only person.
Understood.
And if they have accepted and did not approach this honorable court, then what can I do?
No, because the moment I say out here, yes, they were wrong. They should have put you on 16/1/2004.
Yes.
The moment I say, couldn't it be unequal for those people who have not come?
My lord, I cannot espouse the grievance of my other
you
colleagues.
no. But you are a senior counsel, you have to assist this court and
Well,
help it out.
yes.
How do this court take care of those people?
Because
I remember there is one judgment of the Supreme Court in the case of medical students, wherein it says that there were certain illegalities, and for which, wherein the Supreme Court said that this decision out here shall apply to those others who have not even approached.
Yes.
Now, because otherwise, what is happening? Yes, he has come. Then what will happen to the others?
My lord, under Article 226, which is the discretion of this honorable court to mold the relief. So, my lord, Lordship is well aware the powers of this honorable court under 226, the scope of 226. So, my lord, how long will this honorable court will stretch or reduce it under 226? My lord, that is before your lordship. But in the present case, my lord, on the issue of non-infringement of.
No, I'm not on that. That I will take care. I'm not on that. I'm saying that how does this court take care of those other people?
Yes.
Because you were appointed on 12/3/1993.
Yes.
If you see, the other people were also appointed somewhere in the year 1993.
Yes.
Therefore, they had completed these 10 years.
Yes.
From 966 to 980 or something. They completed these 10 years also along with you.
Whether from all those people have completed 10 years of service also, I don't know, because
No, it is there. Kindly come to page 83. See, kindly come to 996 serial number.
Yes.
This person was appointed in 1991, 967, 1991, 968, 1992, 969, 1992, 970 is yours.
Yes.
970, then these are after you. Okay.
Yes.
So all these have been appointed, given regularization from 18/5/2010.
Yes.
So can this court just shut its eyes and say that they are wrong in putting you at giving you the regularization with effect from 18/5/2010, ought to have been given from 16/1/2004, and not look into the others who are admittedly senior?
Lordship's query is well taken, well highly appreciated. So, my lord, that aspect of the matter, Lordship, they can kindly take a call on the basis of powers under 226.
there's no problem with that, but the only thing is, say, this court, I am of the opinion that basing upon, I should declare the law
Yes.
and say how they would be entitled to, unless if it is not, it will amount to an infraction to Article 14 and 16.
Yes.
And thereupon, to revise the seniority list.
My lord,
I think then it will apply to everybody.
my lord, because my lord, my humble prayer before the Senate court is review the order, restore my seniority with all consequential benefits. That is my humble prayer.
The consequential benefits will be given. There's no
Yes.
problem with that. But this has to be the revision of a constitution, and thereupon to guard the consequential benefits that will be given. But that needs to be passed in this one. That is what my initial prima facie, without hearing the respondent. That is my initial thing.
My lord,
But yeah, I will request you to find out some judgment
Lord,
tomorrow
my lord,
when I take it up.
my lord, may I pray that this matter be decided on Monday?
Monday,
My
okay.
lord, my neighbor, I just heard my neighbor just had expired.
Oh,
just
no.
now. So
Okay, on
tomorrow I
Monday.
have some certain difficulties for that. So
Okay.
kindly keep it as part on Monday.
On Monday, I will, Monday, but you need to
Yes,
do that
Lord.
homework
Lord, I'll
and find out, because you see, this is going to affect you see, the earlier people, beyond the earlier period, the
Yes.
966 above,
Yes.
these are all appointed subsequently.
Actually, Lordship, 18 of us who were recognized in 2006, who have completed 10 years were denied. But unfortunately, the remaining 17, some of us have retired or are still not nobody decided to pursue. And I was left alone. Now 31 years, running 32, I am a graduate teacher without any promotion. If consequential benefit is given like this, I'll get some little retirement benefit. Scale may not be, but for pension benefit, I will get some benefit.
But for pension, to otherwise also you will get in view of paragraph 47 of the direct recruits judgment. If you are an ad hoc employee, it will date back from the date of your initial appointment.
But higher grade means not to be. If I am promoted to a higher grade, then pension benefit will be there.
But wouldn't that change the entire system out here, taking into account those 8 or 10 people coming inside? Somebody who are senior, the headmaster, because the next course of the judgment is just opening the next course of litigation.
I happens to be a poor man from Bihar who came all the way and joined the service and posted in the most remote area in Punjab district. From my initial appointment since 1993, I have not been transferred. And for the last 31 years, I married a Punjab lady. And for the last 32 years, now I'm running 32, I'm continuing as a graduate teacher. Maybe I was left out because I have no godfather that time.
But that will have another issue out there later on. As regards-
Your lordship query, I'm going to assist your lordship. Let me, I'll give us partner in the Monday.
Yes, it's Monday. Madam, I'll hear you on Monday. Okay. Hearing remains inconclusive. Listed again on Monday.
For admission, item number 20.
Yes, my lord. The issue is in this case, lordship is mostly covered by the judgment recorded in 2019 10409. We also lordship, same as the petitioner was excommunicated by his native village for election purposes. Lordship. This is the second time Lordship I have appealed to approach this order before. I had earlier approached this order before by filing WBC 237 of 2022 Lordship. Now, Lordship, I am a returned candidate. I contested in last year's election Lordship from GP party, along with 3 other candidates Lordship. Now, out of 4 candidates, including me, that is, 2 are from the same village, Lordship, that is the petitioner's village, whom we have read as responded before the village council Lordship.
Where is the impugn order?
Annexure 4.
Page?
43, Lordship. The type copy translated. Type copy is at page 44. It is in the petitioner's dialect. It was published in the local vernacular on July 2, 2022. If I may be allowed to read this.
What did you do?
Lordship, I contested the election, that is all, Lordship.
You contested the election?
Yes, Lordship. Because.
Yes, yes, yes. What is this? You are paying for that?
Lordship, its communication is not based on the political issue. The Indian order speaks for itself.
But how can you, somebody contesting an election?
No, that is not an issue, Lordship. That is not an issue. That is not an issue for excommunicating the petitioner.
What is the ground?
Lordship, there are two Indian orders. There are two Indian orders in the petition, Lordship.
Why have you excommunicated him?
Before the second Indian order, Lordship, may kindly consider the first Indian order, Lordship.
The first Indian order is at annexure 3B, page 35 of the.
May kindly consider how the writ petitioner approaches the court. False statement, subversion of material facts, Lordship. Lordship, may kindly turn to first Indian order, Lordship.
Page?
Lordship, page 35.
Yes.
And page 36 is the translated copy, Lordship.
Then?
Page 35 has been wrongly interpreted, and wrong interpretation of page 35 has been enclosed in page 36. Lordship, may kindly turn to my affidavit. I've made categorical statement at paragraph 5. Paragraph 5 and 6, Lordship. I may be allowed to read, Lordship. Paragraph 5. That with regard to the amendments made in paragraph 4 of the petition, it is stated that the main grievances and challenge made by the petitioner in the decision dated 30/6/2023, whereby the respondent number 4 have taken the decision to excommunicate the writ petitioner from citizenship for its lifetime. The writ petitioner was excommunicated from his citizenship for acting contrary to the customary practices of the village and not related to any election political issues. However, the writ petitioner is desperately trying to project his case that he was excommunicated from the citizenship based on the political issue, which is not correct, not supported by records. This is important, Lordship. It is pertinent to mention herein that as regards the Indian order dated 6/2/2023, which I have read, Lordship, the said letter was issued as a reply to the letter dated 15/2/2023, by which the writ petitioner sought permission from the respondent number 4 to visit the village for declaration as a candidature during the recently conducted state general election. The respondent number 4 denied his request to hold program in the village as there was law and order problem within the village in view of prevailing conflict between the supporters of two contesting candidates. Therefore, by the said Indian order, he was requested to leave the village for a while in order to restore normalcy in the village. However, the said Indian order dated 16/2/2023 was wrongly translated to suit his own purpose. The relevant part of the wrong translation of the order is reduced herein below. It is in the interest of the village, we the Chungja Suiso are temporarily debarring you from the part of Chungja village. Therefore, the petitioner may be put straight proof of the correctness of the said translation. Wrong translation has been enclosed in the writ petition, that is the Indian order, Lordship. And the next paragraph, Lordship, moreover, against the Indian order dated 16/2/2023, the writ petitioner made a complaint to the Deputy Commissioner Mohokchong, and accordingly, the Deputy Commissioner Mohokchong summoned the Chungja Village Council, and the meeting was held on 17/2/2023. at the office of the Chamber of STUC and Returning Officer 28 AC. The issue was resolved between the parties amicably with necessary instruction by the STUC on 17/2/2023. However, the said meeting dated 17/2/2023, which is the termination of the complaint made by the writ petitioner, is not a part of record in the present writ petition, and there is not even a whisper about the said minutes. The writ petitioner suppressed such material facts, therefore, the present writ petition is not maintainable and liable to be dismissed on that ground allowed. As regards the other statements of filing, that is not issue. So, Lordship, the first MB order is a wrong translation. And the full statement has been made by the writ petitioner in the writ petition. So as to.
Kindly come to paragraph 7 of your writ petition, of your affidavit.
Paragraph 7, Lordship.
Paragraph 7. This court had read the 17/2/2023, where the SDO had made it very clear to the village council out here that you cannot forbid the petitioner from participating or to making any declaration here. Only thing is that he has to ensure that there is no animosity being said. Now let us see paragraph 7 thereupon. What is the ground? You say that he should not have come to the village.
Yes.
He has come to the village and he has come to the village with police. That is the reason why you have thrown him out.
No, this is the second MB order, Lordship. I'm on first MB order, Lordship.
First is your thing is there has been some animosity which is going on, for which till normalcy returns, you have asked him not to come. That is your basic thing which you have stated.
Against that, the petitioner
has misinterpreted that and have not given the correct translation. That I've understood.
Yes,
we are now, forget about the temporary, now you have made it permanent. The permanent has been made on the basis of the reasons which have been assigned in paragraph number 7 of your affidavit.
Paragraph 7 and 8, Lordship.
In 7 you say that he has been debarred, but then why did he have to come? And that too he has come with police. And that is why the customary practice have been violated, for which he has been debarred for life.
I've testified in paragraph 7 and 8. As regards the second MB order, Lordship.
That is it.
The
What
order
is
by
8?
which the writ petitioner was excommunicated from the village. May I read, Lordship, paragraph 7 and 8?
Yeah, it is the same. The 8 is same. The reason is deployment of police personnel without the knowledge of the village council. Lodge a complaint dated so-and-so to the deputy governor requesting him to withdraw the security forces from the village immediately in order to conduct a meeting peacefully, ensure peace. Can be the reason to excommunicate him for life. You may have practice out there, but then also is the village council out here. This village council, who had excommunicated him? The village council.
The village council.
Now, this village council is an authority established under the village council.
Yes,
Act.
sir.
So under such a way, it will be Article 12.
Yes, sir.
If it is an authority under Article 12,
Yes,
or
sir.
if it comes under the other authorities also, then also, how can you do that? Because of the fact that he has asked the police to come. He may have some grievances that they are not allowing me, but the preceding letter dated 17/2/2022 or 23 categorically shows that this person concerned, the SDO had asked you that you cannot stop him from making a declaration. But only thing is, yes, I would have understood that he comes out there, creates does something, thereby spoils the normalcy out here, or creating an atmosphere of animosity for which you do something that is a different aspect of the matter. But how can you throw him out for lifetime? And that to lock his doors, every property, everything.
Yes, Lordship. Now,
Lordship, my only submission is so far as the excommunication of the writ petitioner is concerned. That is another aspect of the matter, Lordship. Before deciding that excommunication, Lordship may kindly decide the first impugn order, how the writ petitioner approached this honorable court. False statement, subversion of material facts. What is such type of conduct?
Understood, but this court is exercising
It's permissible,
26.
Lordship.
Can this court just shut its eyes on the on the right of a property,
That
right
is-
of life,
that is
right
the
of
second-
liberty?
second aspect of the
A
matter,
person's liberty is being taken away to move around, which is a liberty under Article 19 being taken away. A right under 19(1)(a), 19(1)(a) to profess has been taken away. The right to contest an election is being taken away. You are not debarring him from entering. Can it be done? Understood. At one point of time, the village councils or the village could have very well done it, but as of now, if you are a creation of a statute, can you do that?
Lordship, so far as the violation of the fundamental rights is concerned, I have nothing much to see. But then,
But this court cannot shut its eyes on this.
Lordship,
Understood. There are many the things that he has done out there, but that doesn't mean that. I'll do one thing. I'll post it on Thursday. Tuesday. I expect you to advise your clients to withdraw this. Advise it better off. Because why I don't want to do it, I'll set aside this. If I set aside this, it will further create more animosity. If you withdraw it, it is better off. You advise your client to withdraw this, better off. List the matter again on 27th of February 2024 for further hearing.
For admission, item number 21.
Because if he contests also, he's not going to get a single vote from you. But to lock him out is very difficult. Yes.
Lordship, the petitioner is a treasurer, senior treasurer officer.
To your lordship's permission, before my learned colleague who makes a submission of merit, I have raised preliminary objection on mentionability, your lordship.
What is this matter about?
By this petitioner is challenging the order passed by Lokayota, recommending to the authority to initiate disciplinary proceeding against the petitioner. And also the memorandum proposing to initiate disciplinary proceeding against the petitioner issued by the state respondent. These are the two orders which is under challenge, your lordship.
There is so-called notice issued by whom?
By the disciplinary authority, that is the additional chief secretary and the finance commissioner.
Set aside and quash the impugned order dated Upalokaayukta. Quash and set aside the impugned so-called notice. Quash and the impugned notification dated. What is this 18/2/12? Where is this 18/12?
The memorandum issued by the state respondent is page 74. And I am referring for Lokayota, your worship.
And just 1 minute, let me. Yes.
Yes, Your Lordship.
Why? Why should this
The
court?
petitioner has only acted in accordance with the treasury rules.
What,
The general treasury
Mr.
rules-
Counsel,
Yes.
there is the effect of a Lokayukta's order is a recommendatory.
Yes, Your Lordship.
They have made a recommendation to the authority
Yes.
concerned to initiate a disciplinary proceeding.
Yes.
Now, on the basis of that, a disciplinary proceedings have been initiated. Now, what happens in the disciplinary proceeding? Why should this court to interfere at this stage under Article 2 to 6? What is wrong?
Your Lordship, pending the disciplinary proceedings, Your Lordship, I have approached this honorable court, but Your Lordship may see whether I have committed any offense.
No, I'm not going to look into it. Mr.
Because if
Counsel,
I have to
Mr.
wait-
Counsel, I
Yeah.
am sitting in a glass cabin out here. That doesn't mean that you are going to take me as a disciplinary authority. I'm not. That fact as to whether you have committed any illegalities or not, whether the disciplinary action has to be initiated, has been initiated, or you have to be punished, is for the disciplinary authority to decide.
Your Lordship,
Why should this court at all interfere?
Your Lordship. in
Because
this
you
case-
see, the jurisdiction under Article 226 is not a jurisdiction to be exercised just for the sake of it.
Your Lordship, it is true, Your Lordship, but in the absence of any offense committed, how can a disciplinary proceeding be conducted?
So you have to, you reply.
I have made submission, I have submitted my replies, but no
Very well.
action was taken in the meantime.
No, if it,
Then
you,
what
if,
happened?
Mr. Counsel, if
For
you
now,
have
2 years.
submitted a reply, an inquiry, the disciplinary proceedings at best is required, this court can at best direct that the disciplinary proceedings be culminated within a period of a short period, within 6 months if you want, if you have any difficulties. But this court is under no circumstances going to interfere
Your
with
Lordship,
it.
yes, but if the entire proceeding.
And this court can also say that with the disciplinary proceedings shall proceed with the disciplinary proceedings without being influenced by the observations made by the Upalakant. That's done. Nothing more.
And the fact about the rules, maybe.
That too you have already raised.
Yes.
So the question is, the disciplinary proceedings are now actively considering the aspect and needs to be considered and done, completed within at a short span of time, within a period of 6 months.
Your Lordship, maybe
You don't want the period.
lesser than that, more than 2 years, Your Lordship. The petitioner has been deprived of his office for more than 2 years, Your Lordship.
No, it's okay. Now, if there is a disciplinary proceeding against you, this has been done, the initiation has only happened in 2021.
Yes, Your Lordship, now it is more than 2 years.
21. So
And that also.
the so-called notice has been issued in 2021. You have submitted your reply. So within 6 months, let it be
And
completed.
the petitioner has also been told, he has gone and submitted submissions already. That he is.
Now we direct them to complete it within 6 months. That's a fair thing. The inquiry officer, the disciplinary proceedings be completed within 6 months. What do you say, madam? That's it. I need not go into the
Your
question.
Lordship, the petitioner has been deprived of his duties, so if the period may be reduced to 4 to 3 months. 3 months, Your Lordship. Now.
Mr. Counsel, Mr. Counsel,
Yes.
if I don't dispose of the matter today, this matter will go for another 2 months, and thereby another 6 months or 4 months if it is given. No court is going to set aside the disciplinary proceedings. So under such circumstances, at the end of the day, you will again be having another 6 months after 3 months.
Your Lordship, I would like to.
She said, I'll say that she has submitted the reaction, so I'll put an outer limit within 6 months.
But Your Lordship, I would like to impress upon Your Lordship that all this has been, the entire proceeding has been a sham. The
Understood.
petitioner has only performed duties in accordance with the provisions of the rules. Your Lordship.
Understood.
Yes, now.
But as of now, this court, why should this court step into the shoes of a disciplinary authority? Tell me, why? When there is allegations which are a question of fact, you say that you are doing in terms with that act. Very well. If it has been done in terms with the act, it is a question of fact whether you have done or not.
No, it is Your Lordship with regard to release of bills. In
Release
accordance
of?
with the rules. The rule says that I cannot stop as per the rules. I have no power to deny when bills come before me. It is my duty to, my only responsibility is that if there are some mathematical errors, I can make corrections after informing the necessary authority. Apart from that, it is my duty to release the peers.
Have you been suspended?
It is more or less like a suspension.
No.
Power
More or
was
less
taken
what?
away
Are
from
you
me.
suspended?
Yes, power was taken away from me. It's more or less a suspension order, Your Lordship.
More or less suspension?
Yes.
Are you getting, what is this more or less suspension?
Power of the TDO has been taken away from me. Power of the treasury officer has been taken away from me. But the order is such that there is no effect to my salary and all. I am made to just sit at home. The power, my power as a treasury officer has been taken away. And the rules, as per the rules, I am powerless to, when it comes to the.
Okay, madam, you complete it within 3 months.
4 months left.
4 months. Nothing more.
This aspect may be.
The instant writ petition has been filed challenging the order dated 15/11/2021 issued by passed by the Upalukayukta of the state of Nagaland, semicolon. The show cause notice dated 18/12/2021 issued to the petitioner.
Lordship, there
2021 issued to the petitioner.
two orders passed by Lokayukta. That is order dated, first order is correct, Your Lordship, 15/11/2021. And the second order is
challenging the orders dated 15/11/2021 and 11/5/2022
Lordship.
by the Upalukayukta of the state of Nagaland, as well as the initiation of the disciplinary proceedings by issuance of the show cause notice.
Memorandum dated 3/3, page 74, Your Lordship.
Show cause notice is dated what?
Show cause notice is maybe for the earlier, but the final order memorandum is dated page 74, Your Lordship. 3/3/2023. 7/4. Proposing to hold inquiry. These are the 3 orders challenge.
This is the charge sheet. Page 74 is the charge sheet. Memorandum of charge. The instant writ petition has been filed challenging the orders of the Upalukayukta dated 15/11/2021 and 11/5/2022 passed by the Upalukayukta of the state of Nagaland, semicolon, for setting aside and quashing the show cause notice dated 18/12/2021, semicolon, the notification dated 18/12/2021, as well as also the memorandum of charges dated 3/3/2023. Full stop. This court have heard the learned counsels appearing on behalf of the parties. It is well settled that the orders passed by the Upalukayukta, the Lokayukta as well as the Upalukayukta under the provisions of the, what is that act name?
Under Nagaland Lokayukta Act.
Under the Nagaland Lokayukta Act
2017
is recommended in nature. Full stop. Further to that, this court have duly taken note of that on the basis thereof, the disciplinary proceedings have been initiated upon the petitioner. And the memorandum of charge was submitted to the petitioner on 3/3/2023. The learned counsel for the petitioner further submits that in pursuant to the memorandum of charge, the petitioner had also submitted his statement of defense. However, the said inquiry proceedings have been prolonged and thereby the petitioner have been deprived of exercising his duties, although he has been deprived of exercising his duties in the true extent. Full-stop. The learned counsel appearing on behalf of the petitioner further submitted that the said disciplinary proceedings had no basis inasmuch as the petitioner have acted in accordance with the provisions of law, and more particularly the
Central Treasury rules.
The Central Treasury rules.
The Lordship is only given as Central Treasury rules.
Central Treasury rules, which is applicable to the state of Nagaland. This court, having given an anxious consideration to the above, this court have put a specific pointed query upon Ms. So-and-so, the learned counsel appearing on behalf of the state of Nagaland, and more particularly the disciplinary authority, and inquired as to how long the said how much time would be required for completion of the said departmental inquiry. The learned counsel submitted that the same would be done at the earliest. So, taking into account that the orders of the Upalokayukta are recommendatory in nature, and there is a departmental proceedings which is presently going on, it would not be proper on the part of this court at this stage to interfere with the said departmental proceedings. However, for the ends of justice, this court directs the said directs the respondent authorities to complete the said departmental proceedings within a period of 4 months from today. Further to that, this court observes and directs that the inquiry officer shall not be influenced by the recommendations so made or influenced on the basis of, shall not be influenced by the orders dated 15/11/2021 and 11/5/2022 passed by the Lokayukta in case number A.NLP-11/2021, case number A.NLP-8/2021, and case number A.NLP-10/2021 in arriving at its report. With the above, the instant petition stands disposed.
My friends, for respondent number 4.
Mr. T.B. Jamil had appeared on behalf of the respondent number 4 and had submitted that the initiation of the instant petition against the Lokayukta, now against the respondent number 4 is totally unwarranted in view of the fact that the recommendations, the orders which have been passed by the Upalokayukta are recommendatory in nature, and as such, no writ lies.
One clarification. With the disciplinary, instead of the inquiry officer, if the direction will be that the disciplinary authority shall not be influenced by recommendation of the part of the
Disciplinary and authority, including the inquiry officer.
For admission, item number 22.
How many? Yes. Okay. Pass over. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 2 weeks.
Much obliged.
For admission, item number 23.
Please, your lordship, on behalf of K. Angami, may I pray this matter be listed after 3 weeks. I'm informed that he is yet to receive instruction. I'm informed that he is yet to receive instruction from the state respondents.
Okay, you have not filed your affidavit, no?
Lordship.
The counsel appearing on behalf of the respondent state seeks for an accommodation of 3 weeks for filing the affidavit in opposition.
Lordship.
List the matter again on 22nd of March 2024. In the meantime, the affidavit be filed by 18th of March 2024.
There is an interim.
The interim order passed earlier shall continue till then.
For admission, item number 24.
That's why I beg to mention on behalf of each of the if Jews may be granted also. Matthew's instructions. Lordship.
The request of the council, yeah, go and start order to you.
Yes, Lordship.
You file your affidavit by 18th.
For admission, item number 23.
We have already made a mention in item 23, your lordship.
But I didn't allow anybody's any mention.
Lordship.
Yes.
Lordship.
No, there is a
It
stay
should be
operating,
25.
huh? There is a stay operating. You same order, you file your affidavit by 22nd, by fixing it on 22nd, the affidavit
Yes,
be
your
filed by 18th. Interim order passed earlier shall continue till then.
For admission, item number 25.
Yes, madam.
Yes, your lordship. Lordship, this is matter seeking appointment from admission. Last order, state has been directed to file affidavit, but still they are yet to file the affidavit.
Yes, government not filing affidavit in spite of an order passed.
On behalf of my colleague Arjun Lee, he may be granted some time to file affidavit, your lordship.
No, here is a case where the petitioner is asking for a compassionate appointment in terms of
Lordship.
17(9).
Then, your
Now,
lordship,
the question
as per
is
the own-
filing affidavit, no affidavit doesn't matter. Here is a case whether you have considered him, whether he, what is the present status of him? Have you taken into consideration? File
Lordship,
that
let
only.
it come up next week, your lordship.
Next
I'll
week,
inform
you
my
just
colleague.
get your instruction, what is the status in the roster?
Lordship.
I don't think may be taken up today because filing of affidavit may not be required also.
Not required.
Because I'm facing a lot of financial hardship.
No, in fact, today I have passed a judgment on this compassionate appointment. This is police. Police will have a different thing, nah? The roster is it same because you are having group C and group D.
Lordship.
Is
But
it the
actually,
same?
The brief is with my colleague, your lordship. I
No,
don't
no,
have
no,
the-
I am asking you. You are the
Lordship,
state
it will be
council.
the same, yes, the OM. It will be the
No,
same.
no, whether it would be the same for all, whether there will be a composite roster for all departments,
Roster, different departments has got.
different,
Yes,
different
yes.
rosters.
Yes, yes.
In my case, my lord, the post is still vacant.
Because I still have the roster for that school education.
Lordship, that is
School
different.
That is
would be
different. This is
Yes,
different. no?
Yes, yes.
Okay. List the matter again on 29th of February 2024, on which date the Learned Council for the state shall apprise as to what is the present status of the petitioner's application, what is the present status of the consideration of the petitioner's application.
From the supplementary course list for hearing, item number 50 to 71. 51 to 70.
Yes, madam. AG, I've already heard him. His basic case is, if I could understood, his basic case is they were appointed against vacant post.
Yes, Lordship, sanction post.
Vacant sanction post. And you have already stated out there that these people who were appointed in 2010 or 11 or 13, they do not come within the ambit of the.
No, Lordship, they were appointed against the SSA and RMSA sanction post. It's under a centrally sponsored scheme. Only in respect of the 2010 employees, a condition has been made that after the winding of the SSA program, their salary will be borne by the state. Yes, only in respect of 2010 graduate teacher. So, Your Lordship, they
But the appointments were
against the central sponsored scheme.
sanction post, not only that, against the head of account.
Yes, against even the salary, everything has been borne by the SSA, by the mission authority.
Then?
So they have been representing to the government, saying that since in their advertisement, the post that advertised was SSA and RMSA post was not stipulated in the advertisement. For that reason, they have been making a representation to the government to gather them into the state gather. The petitioner also knew that they are holding an SSA and RMSA post. So after the cabinet, they took a decision and they entered them into the state gather with effect from 21 April 2022. So they became a state gather only from 21 April 2022.
So they want to be in the state cadre from
the date of the initial appointment. Yes. So you know, if at all they are agreed with the general gesture by the government, then they can be reverted back to the SSA and the RMSA, because still now also the scheme is still functioning.
Respectfully, Your Lordship, the issue is already dealt with by this honorable court, and they have specifically submitted. It's on record, Lordship. I'm not making a submission out of the submission, Lordship. They have admitted before this honorable court that we are state cadre, Lordship. In the other case, the 2015 batch, when they wanted a salary equivalent to our salary, they're also in their affidavit and their submission, they have made a specific submission that the 2010 and 13 batch are state cadre, Lordship. How can they turn around like this? Respectfully, my lord.
Yes,
my
paragraph
learned
9.
friend's submission is very misleading, my lord.
Mr. Joshua, is paragraph 9?
Yes, Lordship.
Of the judgment which was rendered?
Yes, Lordship.
Where they, I think.
They have made a specific categorical admission, Lordship, before this honorable court.
Our brother Sema was there.
Yes, my lord.
At that point of time as the additional AG.
Yes, Lordship. Not only that, the 2010 and 13 batch have also approached this honorable court against the 2010 or 2015 seniority list. And there, in that seniority dispute, the 2010 batch who were included in the seniority list were placed behind those who were appointed without a regular selection process.
But
and
Madam,
senior,
Madam AG, kindly tell me one thing. See that document, which this is not the file. Which file you were saying? 311.
311, Lordship. 311.
311. Item number? What is 311? That day you showed me a document wherein they filed an affidavit.
Yes, Lordship.
Wherein the head of account has been mentioned somewhere. Yes, yes. Kindly come to your affidavit in 311. How these posts were created. Page 12A.
Your affidavit, the state's affidavit, 12A. Your affidavit, state's affidavit, page 12.
Page 12, yes.
12A.
This is
This is the creation of posts.
Yes, creation
Now,
of,
if these are the creation of posts by the governor of Nagaland,
yes.
that means the government, this is not a under the RMSA or SSA, can the governor of Nagaland create a post?
Your Lordship, the notification says that EDS, SSA, CPA. The governor of, this is the type of P, the original copy would be.
Page 12. The governor is pleased to
Yes,
accord
yes.
sanction.
The governor of Nagaland, Nagaland, pleased to accord sanction for creation of 210 temporary posts of graduate teacher, such and such, at the rate of for English, science, and maths for each school as indicated in the annexure.
So,
Then the
if
expenditure.
now tell me,
Yes.
can SSA post or RMSA post be created by the governor? No.
Your Lordship, we got the sanction approval from the ministry.
No. Whatever may be, can the post be created by the governor? Because the governor acts only on behalf of the state.
On the recommendation of the cabinet, Your Lordship.
Cabinet advises the governor.
Yes.
But can the governor create a post in respect of a centrally sponsored scheme? I'm asking you a specific question as to whether the governor can create that post. Because the moment the post is being created, the question of budget is involved. Yes, initially you may receive an assistance from the SSA.
Yes.
That's a different aspect of the matter. Because you are thereafter saying that all this payment will be made by you later on.
Your Lordship, in my paragraph 2, page 2, paragraph 2. 2.1.
Therefore, normally what happens in SSA
Yes.
or these are contractual activities.
So, you know, yes, it's a contractual, yes, Lordship.
So these are all SSA, RMSA,
Yes,
or
yes.
you go for the mission, what is that other mission? The health mission,
Yes.
These are all contractual
Exactly,
appointments.
Lordship. So, Your Lordship, at the time of advertisement, there was no stipulation that the post advertised was meant for SSA and others.
Not only that, in your creation of the post, how could you create a post? You can't create a post. Therefore, always the issue is, can you bring them within the fold of the regular calendar?
Lordship may come to this one. This will make it more clear. 14, page 14, Your Lordship. The type copy is at 15A. Page 14, Your Lordship.
15A.
Yes.
Yes.
This is dated 21st March 2011 for one statement showing 1,271 number of posts of teacher against 1,007 primary school and 1,335 number of posts of teachers against 449 middle school under the SSA program. So, Your Lordship, we have created 2,606 temporary posts of teachers under Sarva Shiksha Abhiyan. So the posts which the petitioner are holding are all SSA and RMSA. Then the RMSA creation post is at page of 16. And
No. Therefore, you see, 2011.
Yes.
This document and C12A document. It is different.
Because we have created so many posts.
No. Why I'm saying is, in these posts at page 15A, the payment is to be made against Sarva Shiksha Abhijan, SSA plan CSS, Central something. Shall deposit the salaries and so appointed against so on the basis of which salary will be released. Here there is no mention that after the period is over, the payment will be made by the state of Nagaland.
Your Lordship,
Whereas if you see 12A,
Your Lordship, 12A or 3.1, the state mission authority shall deposit.
3.3.
No, but 3.1.
After winding up of the SSA mission,
Yes.
the salary or other benefits of these teachers shall be borne by the state government.
So, Your Lordship, by 3.1, it says that the state missions shall deposit the requirement of salaries for these teachers to the state government account through treasury challan quarterly on the basis of the availability of fund till such time the SSA continues. So, Your Lordship.
Madam, you bring to, as to how posts are created under the Sarva Shiksha Abhijan. Who creates the posts? It's a central government.
Yes, it should be from the central government, Your
Then
Lordship.
the central government gives, if I'm not wrong, because as I was dealing with a matter pertaining to Operation Blackboard,
Your Lordship, they have given the power authority to the state government. So based on that, the state government they created the post.
And we do one thing on another day. I have fixed this matter now when I've asked you to produce the
RTE.
RTE Act, the rules. You were present, na?
Yes.
When next week?
That is on Wednesday, next Wednesday. It's a DB.
DV, na?
Yes.
Okay. You see, you have these RTE rules.
Yes.
These RTE rules normally, when the state makes it, it is categorically mentions what are the rights of those persons who are outside the cadre. They are also given the similar benefits.
Yes.
Let's see.
So they are also getting the similar, when they were appointed, they were given the same scale of pay as that of the regular employee, Lordship. Yes.
Pension and everything.
No, not pension.
No, that has to be given in view of 21B or something of the RTE Act. See the RTE Act, you have it?
I do not, Lordship, but even otherwise.
Always you are not prepared with all.
No,
whenever I
Lordship.
put
My Lord
questions.
will kindly appreciate this. This is a settled issue before this honorable court. I do not know why the state is now turning around to make this submission. When the issue is already decided by this honorable court, it's annexed with this Lordship. I can satisfy your Lordship, that I assure you, Lordship.
No, that was not the least before a court.
My Lord.
That was an alternative submission being made just to show, you see, what submission which was made by the state at that point of time was, look here, these people out here were actually regularly appointed, these are not. That was the submission being made.
Yes, Lordship.
To show that, you see, these are these, but that is not the issue.
No, that is one aspect of the matter, my Lord. I agree with your Lordship. The other issue is to protect our seniority. We have approached this honorable court. And Lordship.
Where is that?
Yes, my Lord. My Lord, I'll take your Lordship to the judgment.
Oh, Mr. Jamir, sorry, I can't take your matter today.
Oh, my Lord.
You want it on some other date, Mr. Jamir?
204, my Lord.
When do you want it? Any date? 26th. You mentioned, you asked your junior to mention the matter for upgrading. I give it out there. What is your item number?
33.
33. I list the matter on 26th. Liberty is given to the councils appearing on behalf of the parties to mention the matter for upgrading.
May I take your Lordship to page 204. My Lordship, the brief facts of the case in this case is that those who were irregularly selected, Lordship, are appointed.
204, where is it?
204.
No, you were saying about the names.
Page 204, my Lord.
No, page, it starts at 293, 292, the judgment.
Annexure 120, 120.
Understood. The judgment starts at page 292.
No, Lordship, 204.
204 is the judgment, the name of the parties.
Yes, Lordship.
I'm asking you, where is the relevant portion?
Oh, Lordship, my lord.
Yes.
Yes, Lordship. That it starts from 292, as my lord has rightly said. So, my lord, here, those irregularly selected appointed candidates, Lordship, they were made senior to those who were regularly selected. Because,
Were you a party out there?
No, it's not the party.
my lord, I'll come to that. I'll satisfy your lordship if my learned friend would not disturb me, my lord. Here, in this,
Yes, ma'am.
yes, your lordship.
Yes, yes,
So,
Madam AG, please have your seat. Let me
the-
have
yes, my
his
lord.
satisfaction also.
The irregularly selected candidates, their seniority was to be counted from the date of their appointment, not from the date of their regularization. That is why a group of petitioners, there are different, not just one writ petition, lordship, several writ petitions were filed. Here, this honorable court observed that those who were irregularly selected lordship, appointed lordship, their seniority would be counted from the date of their regularization and not from the date of their appointment, lordship. So, my lord, may kindly come to page 13, 313, paragraph 26.
Yes.
Further, the government of Nagaland Home Department has issued memorandum number such and such, 1975, 2004, and letter dated 24/3/1976, whereby it is the consistent policy of the government that the seniority of the ad hoc contract ad hoc appointee will be counted only from the date on which they have been absorbed on regular basis. The action of the state respondents while issuing the GT seniority list of 2015 is in violation of this memoranda and letter of the government of Nagaland. In the facts and circumstances of what has been discussed here and above, the petitioners in WPC number 214K of 2015 has made out a case, and accordingly, the impugned GT seniority list of 2015, the letter dated 18/6/2015, written by the Undersecretary to the Government of Nagaland's School Education Department to the Director of School Education, conveying the approval of the government in accepting the principles recommended by the Committee for Preparation of Seniority List of Graduate and Primary Teachers in the School Education Department are set aside and quashed. The state respondents are directed to arrange the seniority of graduate teachers within 3 months from today. Any promotion made subsequent to the graduate teacher seniority list of 2015 shall also be reconsidered by the state respondents. Now, your lordship.
But that is not the issue here.
No, my lord, what I'm trying to prove.
But Mr. Joseph, kindly appreciate,
yes,
there is a concept of a ratio decidendi, one is an obiter. This may at best be said to be an obiter touching on this or that. But here the issue out here is whether those persons who were appointed in so and so and so and so
yes, lordship,
can be considered as entering into the cadre of the state of Nagaland as on the date of their appointment, or is it on the basis of a subsequent absorption made in the year 2022? Isn't that the issue?
That is why, my lord.
Which is not the issue here. Huh?
Now, my lord, I will satisfy your lordship. My lord, may kindly allow me to take your lordship to page 315. 315. Now, the present petitioner's lordship. The present petitioners filed 3 writ petitions, lordship. WPC number 122K of 2017, WPC number 170K 2017, with WPC number 172K 2017. These are petitioners before your lordship in this writ petition, lordship. Now, my lord, here, this is by order dated 1/11/2017.
It is a consensus.
Yes.
So
the state respondents, they agreed that our case is also covered by the earlier judgment.
No.
Which we have read, lordship.
The state respondents have agreed that from the date of their absorption into the regular basis will be the date. This judgment, in fact, goes against you.
No, how will this go against me, my lord? Respectfully, my lord. Perhaps, yes,
Now,
lordship.
kindly see, the earlier judgment was rendered, it was mentioned categorically that
My
you
lord.
see what the seniority list has to be taken into account on the date on which the person is absorbed into the regular cadre. See this paragraph. Kindly see paragraph number 26, which you have read at page 313.
Lordship.
And as such, those people who have not been taken, absorbed on the basis of the initial appointment out there would not be, it's wrong, for which there was a direction that there has to be a rearrangement of the seniority list.
Yeah, that is why, Lordship.
That is why.
Now-
Now, therefore, the basic case out here of the particular state is, look here, we have absorbed them into the regular cadre only in the year 2022. And as such, this judgment goes in our favor. Isn't that, madam?
Perhaps, my lord, respectfully, my lord, I think my lord is not.
Mr. Joshua,
yes.
I think the only way out is, first let us see as to whether who creates post in Sarva Shiksha. You get the clue answer there. If in Sarva Shiksha, does the government of Nagaland has the power to create post? If it does not have the power to create post, then in that case, any creation of the post has to be deemed to be a creation of the post.
The
by
government has
of
no right
Nagaland.
to create post, Lordship. It is the society, Lordship, Nagaland Education Mission Society. They are the body that has been entrusted by the central government to create posts, not the government of Nagaland, Lordship.
That is what I am saying.
Yes, Lordship.
If the body has been entrusted to create posts, not the government of Nagaland, then the government of Nagaland creating the post makes that these posts are within the state
My
cadre.
lord. Exactly, Lordship.
So that is what I've been asking, madam.
Yes, Lordship.
To find out and tell me as to whether the Sarva Shiksha posts have been created by, can
By the
the
government
governor of Nagaland create that?
I can bring that to your Lordship's attention, Lordship.
That is the crux. The
Yes,
moment
Lordship.
you get there,
Yes,
the answer is there everywhere.
Lordship.
Because they
Well,
cannot. Because if I tell you why, I was dealing with a matter in this principal seat pertaining to old pension, new pension.
my lord.
Now, what has happened? There was an Operation Blackboard scheme of the central government at the time, saying that for the purpose of giving impetus, there has to be certain, the central government is going to pour in funds for that. Then what happened? The government of Assam created certain blackboard posts.
My lord.
And there were two states. One was 4,900 posts and the other is around 7,500 posts. In the first thing, it said that these posts are subject to have been done at the behest of the government, but after the assistance which is being over, the state would be paying it. And accordingly, these 4,900 were absorbed. But as regards the 7,500, it was the category that said that these are just operational blackboard posts, which is subject to the amount which we are going to get. So after 11 months, it will be over. So what happened in view of various orders passed by this court, by the court bench, there were directions to regularize them. And thereupon the government regularized them sometime after 2005, 1 to 2005. Now these persons out here came out and said that, you see, there was a direction for regularization. So it has to date back from the date of the appointment. Now with the date of the appointment being there, if we go by this, taking into account the direct recruits case, more particularly paragraph 47, they said that they are entitled to the old pension scheme. So therefore, the question arose as to whether it was a creation of the post by the government or there was a direction to create post. That power has been given. But in these cases, RMSA or SSA or even the National Health Mission, these are all contractual appointees.
Yes, Lordship.
But if you create a post, you don't create a post in vacuum. A creation of post is based upon a budget. And this budget is being very well taken care of by the authorities, taking into account that this is the amount which we are going to get from the central government as assistance. And see, there are two aspects. One is an assistance, and one is where the central government pays. Here is a case where the central government is giving an assistance, which only for the purpose of that. In the state of Nagaland, there's very less post out there. Central government is pouring out certain amount. So under such circumstances, these persons, can it be said the creation of the post, the governor of Nagaland had therefore created the post? Maybe they are going to get the central government assistance. And if it has been the creation of post is being made by the government of Nagaland, then it has to date back from the date of the appointment. The answer is to that effect.
My lord.
So the basic crux is, does the governor of Nagaland has the power to create post in Sarva Shiksha?
No, lordship.
You show me that, both of you.
Yes,
Next Monday, tomorrow, when?
tomorrow may not be possible.
Monday, lordship.
Monday.
It is the Nagaland Education Mission Society, as far as SSA and RMSA are concerned.
Just find out
Yes,
who
lordship.
creates the post, because
I
that
will
is
place
your
before you,
answer.
lordship. Yes, lordship.
Hearing remains inconclusive to be listed again on Monday.
Bless you, lordship.
Okay, let me rise. But you go through the rules. That rules is very relevant also. The right to education rules of the Nagaland.
My lord. Bless you, lordship.
What time, sir?